Coming up tonight on C-SPAN, FBI Director Christopher Wray and Deputy Attorney General Rod Rosenstein testifying on the Clinton email probe. Then debate from the U.S. House on a resolution requiring the Justice Department supply documents in the Russia investigation. And later, the American Constitution Society reviewing the recent Supreme Court term. Deputy Attorney General Rod Rosenstein and FBI Director Christopher Wray testified on the Justice Department's Inspector General report that focused on the 2016 Clinton email investigation. In this first portion, the committee voted to waive the 7-day notice rule, which requires at least 7 days advance notice of a scheduled hearing to be sent to all members of the committee. The chair of the committee, Bob Goodlatte, and ranking member Jerry Nadler gave their opening statements, and then the committee recessed for votes on the floor. This portion is 30 minutes.
Members of the media would retreat. We're going to start this hearing. Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare recesses of the committee at any time. Before we begin our hearing this morning, we need to vote to waive the committee's 7-day hearing notice requirement. Pursuant to Clause A of Rule 3 of the committee rules, the question is whether there is good cause to begin today's hearing less than 7 days after it was noticed. Those in favor will say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and we may proceed with the hearing.
Mr. Chairman, I ask for a record vote.
A recorded vote has been requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Yes. Mr. Poe votes yes. Mr. Marino? Right. Mr. Marino votes yes. Mr. Gowdy? Yes. Mr. Gowdy votes yes. Mr. Labrador? Mr. Collins? Mr. DeSantis? Yes. Mr. DeSantis votes yes. Mr. Buck? Mr. Ratcliffe? Yes. Mr. Ratcliffe votes yes. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Aye. Mr. Biggs votes aye. Mr. Rutherford? Aye. Mr. Rutherford votes aye. Ms. Handel? Ms. Handel votes yes. Mr. Rothfuss? Aye. Mr. Rothfuss votes aye. Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen?
Yes.
Mr. Cohen votes yes. Mr. Johnson of Georgia?
Yeah. You may not understand Russian yet. You will. No.
Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Deutsch votes no. Mr. Gutierrez? Mr. Gutierrez votes no. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? No. Mr. Schneider votes no. Ms. Demings? No. Ms. Demings votes no.
Has every member voted who wishes to vote?
Mr. Chairman,
Gentlewoman is recorded as no.
I can't hear you, please.
you want to ask? Or are they waiting on that?
No.
We're going to wait another minute or two for the ranking member. So, are you recorded? The gentleman is recorded.
Mr. Chairman, how am I recorded?
Yeah. The
Not
gentleman
recorded.
from Louisiana is not recorded.
Yes.
Mr. Johnson votes yes.
Mr. Chairman, Matt.
Gentleman from California.
Mr. Swalwell votes no.
Chairman, may I make a parliamentary inquiry?
Gentlewoman will state her parliamentary inquiry.
Mr. Chairman, I'm trying to inquire of the basis of the emergency and the cause that has generated this resolution to ignore the regular order of the 7-day notice of the notice.
It's not an emergency, it's good cause. The gentleman from Maryland.
Yes. How am I recorded?
Not recorded.
No.
Mr. Raskin votes no.
Good guess.
Mr. Chairman, continue your generosity. Could you state for the record what the good cause is?
The fact that we've worked very hard with these two gentlemen, who I very much appreciate adjusting their schedules to be here. I know that they both had, the gentleman from New York.
No.
Mr. Nadler votes no.
The clerk will report.
Mr. Chairman, 17 members voted aye, 13 members voted no.
And the
Mr. Gentleman, would you finish your sentence? You said these two gentlemen.
I'm going to first declare that the vote is approved and the notice requirement is waived. Now I'm going to recognize myself for an opening statement, and I'll begin that opening statement by saying to both Deputy Attorney General Rosenstein and Director Wray that I am very appreciative of the fact that they have changed their schedules to be here so that we could have this hearing today and in a reasonable amount of time after the Inspector General's report and testimony before the committee. And I would also like to acknowledge the presence of John Lausch, the United States Attorney for the Northern District of Illinois, who was appointed by the Attorney General and the Deputy Attorney General to facilitate the production of documents which were not being produced in a timely fashion. We still have complaints, but the situation, in my opinion, has improved considerably. But we'll have new issues that we will address here today as well. So I'll continue my opening statement. The Church Committee was established on a bipartisan basis and chaired by Democratic Senator Frank Church in 1975 to review CIA, FBI, and NSA surveillance abuses, including the improper surveillance of an American icon, Martin Luther King Jr., and other prominent individuals. The committee also conducted a review of the insidious monitoring of political activities of citizens exercising their First Amendment rights. The Church Committee's findings resulted in passage 3 years later of the Foreign Intelligence Surveillance Act. FISA attempts to balance the need for secrecy in conducting surveillance against foreign agents with the protection of Americans' time-honored civil liberties. This history shows we have already found ourselves once before in a situation where the FBI and other intelligence agencies violated their oaths to uphold and defend the Constitution of the United States. In monitoring citizens' political activity, the agencies exercise their responsibilities in a manner unworthy of U.S. officials. The abuses of that bygone era, and really of any era, often happen because of power to influence political currents, power to collect sensitive information, and power to wield surveillance tools in improper ways to achieve improper purposes. That power can and has been abused in the past by individuals at the highest and lowest levels of our government. Fortunately, the power of our intelligence agencies is overwhelmingly used to protect us from those wishing to do our country harm. That is the conundrum. We need our intelligence agencies to have the necessary tools and techniques to safeguard our nation, and we have to be constantly vigilant to ensure these tools are not manipulated by unscrupulous actors. The recent Inspector General's report revealed bias in the top echelons of the FBI during a hotly contested presidential election. It revealed that FBI agents, lawyers, and analysts held profound biases against then-candidate Donald Trump and in favor of his opponent, Hillary Clinton, while those on the other side of the aisle continue to exclaim that these biases are only personal political predilections that had no effect on the operation of one of the biggest investigations in our nation's history. I wonder whether these same members would say the same if text messages had turned up to the tune of "Hillary is a disaster," or "We'll stop her," or cursing her with all manner of expletives, or smugly stating that particular parts of the country smell of Hillary supporters. These types of comments were originating from people who were the fact finders in the investigation. These profoundly inappropriate comments were coming from the individuals who were making decisions on whether to provide immunity to people who had already lied to investigators, and whether subjects of an investigation could sit in on interviews with other subjects of the same investigation. These were individuals who were plainly in positions of great power with the opportunity to place greater, lesser, or even no emphasis on certain facts or interpretations of law. These actions led to complete legal exoneration of everyone involved in sending top-secret emails over personal servers and unsecured emails and setting up a server for the explicit purpose of doing this. These actions even led to exposing at least one classified email to a foreign party that risked serious damage to our national security. Amazingly, considering their overwhelming biases, these people were also the very same people who were assigned to investigate the man that they hated, then-candidate Donald Trump. My reference to the Church Committee is apropos because it not only reviewed abuses by individuals, including the FBI director himself, but focused in on surveillance abuses. Here we now face the same allegations, yet in manner that goes to the heart of our democracy. It is right out of a novel, with salacious, unverified dossiers, reports of informants that appear more like spies for the U.S. government, and application of the aforementioned surveillance powers to collect on a U.S. person once associated with President Trump's political campaign. But it's not a novel, it's real life, and we are here today to understand a little bit more about why we now must review how our intelligence and law enforcement agencies engaged in activity that appears not only wrong, but potentially illegal. All of which brings me to this body's constitutional oversight, mandate, and responsibilities. Our responsibility to the American people is to conduct robust oversight of agencies within this committee's jurisdiction to ensure that taxpayer-funded agencies operate lawfully. Our oversight, though, is only as good as the information we are provided. This committee's oversight has been hampered by both the FBI and DOJ's lack of consistent and vigorous production of the documents we need to hold the agencies accountable. While this production has significantly improved recently, it has felt like pulling teeth much of the time to obtain and review relevant documents. Moreover, we just recently learned that some documents the Inspector General received to conduct his investigation of the 2016 election have been interpreted by the Department of Justice to fall outside the first subpoena I ever issued as chairman of this committee. Shockingly, emails and communications of DOJ officials have not been produced at all. Therefore, we have not received any emails between prosecutors working the Clinton case. Said differently, we are not receiving and have not received potentially enlightening communications between prosecutors themselves, between prosecutors and DOJ management, including former Attorney General Lynch, or even communications between DOJ officials and those with the Obama White House. This is unacceptable, particularly when we had, long before issuing the subpoena, requested all documents provided to the Inspector General other than certain ones pertaining to grand jury material. The Department of Justice and the FBI are not mentioned in the United States Constitution. The President and Congress are. Our constitutional oversight necessitates that institutions like the FBI and DOJ yield to Congress' constitutional mandate. This is non-negotiable because we must assure the American people that the agencies under our jurisdiction operate fairly, treating all equally under the law. This hearing emphasizes the importance of transparency in helping to regain both the perception and reality of impartiality of our law enforcement system. Damage to the FBI and DOJ's reputations is not something any of us desire. But now that both agencies have been on the front pages for so long, we must all work to ensure those stories are able to focus once again on the great men and women performing admirable and often heroic jobs to protect our country. We expect to hear today how the FBI and the DOJ will hold people accountable and prevent this from happening again. Thank you, and I look forward to hearing from both Deputy Attorney General Rosenstein and Director Wray. I now recognize the ranking member of the committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. The events that have led up to this hearing are totally unacceptable. On Monday of this week, you notified us of this hearing without the 7-day notice required by the rules. On Tuesday, you started our committee markup more than an hour late again without notice to the minority. Then you allowed Mr. Jordan to offer an amendment to a resolution of inquiry that was patently non-germane, and then you stood out of view of the cameras in the hallway just off the hearing room while the majority voted to overturn the ruling of their own chair that the amendment was not germane. On Wednesday, you dropped all committee business to interview Peter Strzok, who had already volunteered to come in for an interview before you threatened him with a subpoena. Today we meet so that the majority can criticize the Deputy Attorney General to his face, largely about his failure to produce documents that you know he cannot produce. We will take a break so that we can go to the floor and vote on a so-called resolution of insistence based on the Jordan Amendment from earlier this week, a measure that is without precedent, without the force of law, and clearly a pretext for a move against Mr. Rosenstein that the majority has already planned. And what is the great emergency that justifies this last-minute hearing? Why has the majority abandoned the rules and traditions that govern civility in the House? The tired story of Hillary Clinton's emails, of course, plus a few conspiracy theories about this special counsel. When President Trump and his administration were actively separating families at the border, ripping children out of the arms of their parents and causing untold suffering to thousands of families, that did not merit an emergency hearing by this committee. And now that thousands of children are still separated from their parents, with no clear plan from this administration for reuniting these families, where is the emergency hearing on that issue? We know that Russia, after successfully interfering with our 2016 elections, is actively working to disrupt the upcoming elections as well. We are told this by all of our intelligence agencies. The former National Security Advisor testified that our intelligence agencies, despite this, have received no instructions from the White House to protect the integrity of our election system. Have we scheduled an emergency hearing on that matter? For that matter, have we conducted any oversight at all on election security, on the family separation crisis, on the administration's failure to protect Dreamers, on the Justice Department's radical decision not to defend the Affordable Care Act in court, on the Supreme Court's recent decisions to undermine voting rights and workers' rights, on the President's ongoing conflicts of interest and clear violations of the Emoluments Clause of the Constitution, or in the myriad other pressing issues within our committee's jurisdiction? No. As with so many issues, this committee stays silent. But on Hillary Clinton's emails, sound the alarms. Despite an Inspector General's report that in more than 500 exhaustive pages demonstrates conclusively that the outcome of the Clinton investigation was not affected by any improper bias, political or otherwise, we are wasting precious committee time to chase Hillary Clinton yet again. The Republicans seem desperate to prove that there was some sort of pro-Clinton and anti-Trump conspiracy within the FBI, when in fact the overwhelming evidence shows exactly the opposite. Virtually every action criticized in the Inspector General's report, Director Comey's July announcement, his public comments on the Clinton investigation and refusal to confirm the existence of the Trump investigations, and his October decision to announce publicly the reopening of the Clinton email investigation ultimately harmed the candidacy of Secretary Clinton and inured to the benefit of Donald Trump, and no one will deny that fact. But I guess we shouldn't let facts stand in the way of a good manufactured emergency. According to the Republican memo for today's hearing, today is also an opportunity for members to consider, quote, the Justice Department's compliance with the committee's March 22nd subpoena, close quote. A subpoena that was not issued in compliance with House rules and therefore cannot be enforced. Even if it were a properly issued subpoena, the fight over document production seems to have boiled down to certain documents that the Republicans know the Department of Justice cannot turn over. Much of it evidence relating to an ongoing criminal investigation, the scoping documents outlining specific lines of inquiry in an ongoing criminal investigation, and the identities of confidential human sources still working undercover in the field. And that, of course, is the whole point. As part of their coordinated and determined effort to undermine the special counsel's investigation, Republicans are requesting documents they know they cannot have. If they somehow find themselves in possession of sensitive documents that go to the core of the special counsel's investigation, and if past practice holds, those documents will end up in the possession of the subject of the investigation, namely President Trump, and shortly thereafter on Fox News. And if the majority is rightly denied, they will do their best to undermine the credibility of the Department of Justice, the credibility of the Deputy Attorney General, and by extension, the credibility of the special counsel. They will likely try to hold Mr. Rosenstein in contempt. Some have even threatened him with impeachment. They may argue that he must be removed from his oversight role over the special counsel's investigation. This is an investigation, I might remind my colleagues, that has already yielded 5 guilty pleas and that has led to the indictment of 20 people so far. The President and some of his closest advisors are under investigation for having participated in a criminal conspiracy with a foreign power against the United States. That is an emergency. The President practically confessed to Lester Holt on television that he obstructed the investigation into that conspiracy when he said that he fired former FBI Director Comey because of, quote, this Russia stuff with Trump and Russia, close quote. That is an emergency. But is that the subject of today's emergency hearing? No. Or of any emergency hearing? No, it is not. I know that this has been a hard week for the majority. I know that it must be tempting to change the subject and rally the base with cries of lock her up. But we do not have the luxury of hiding or voting present at this critical juncture for our democracy. We cannot hide from our responsibilities. We cannot hide from our obligation to conduct oversight of a corrupt administration. We cannot hide from our constitutional duty to protect our elections from foreign interference or to stand up for the rules and for our domestic institutions and for the rule of law. And we cannot hide from our responsibility not to interfere with a proper investigation. I ask my colleagues to consider this question as we proceed. When the special counsel's work is complete, when the enormity of what he finds has been laid bare, how will the American people judge your actions today? I yield back the balance of my time.
The committee will stand in recess and return immediately after this vote series to hear the opening statements of the Deputy Attorney General and the Director.
When the hearing resumed, Deputy Attorney General Rod Rosenstein and FBI Director Christopher Wray gave their opening statements. And then they took questions from committee members. This portion of the hearing is just over an hour.
The committee will reconvene. We'd ask the media to at least settle down. We welcome our distinguished witnesses. And as is the practice of this committee, if you would please rise, I'll begin by swearing you in. Sorry to make you keep standing up, Director. I know you're... Do you and each of you swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record show that the witnesses answered in the affirmative. Mr. Rod Rosenstein is the Deputy Attorney General of the United States. Throughout his distinguished career in public service, he has served in several divisions of the Department of Justice, and notably as the United States Attorney for the District of Maryland from 2005 until 2017. Before being nominated by President Trump to be Deputy Attorney General. Director Wray is the 8th Director of the Federal Bureau of Investigation. Mr. Wray began his Department of Justice career in 1997 as an Assistant United States Attorney for the Northern District of Georgia. He then served as in the office of the Deputy Attorney General and was nominated by President George W. Bush to serve as Assistant Attorney General for the Criminal Division. He worked in private practice before President Trump nominated him to lead the Bureau in August of 2017. Your entire written statement will be entered into the record, and we ask that you summarize your testimony in 5 minutes. And to help you stay within that time, there's a timing light at the table. When you have 1 minute left, it will turn to yellow, and then a minute later to red. So we hope you'll keep your time within that limit, and then we'll open it up for questions. So we'll start with Deputy Attorney General Rosenstein. Welcome.
Well, thank you, Chairman Goodlatte, Ranking Member Nadler, and members of the committee. I always welcome the opportunity to appear before this distinguished body, but today is not a happy occasion. Based on my 30 years of experience in federal law enforcement, working with the outstanding men and women of law enforcement, federal, state, and local, in many of your districts, there's nobody who would be more committed to rooting out abuse and misconduct when there's credible evidence that it occurred. The Inspector General conducted a thorough investigation and found that some Federal Bureau of Investigation employees deviated from important principles in 2016 and 2017. Everyone knew about some of those departures when they occurred, such as discussing criminal investigations and encroaching on prosecutorial decisions. We learned about others through the internal investigation, such as leaking into the news media and exhibiting political bias. We need to correct errors, hold wrongdoers accountable, and deter future violations. Director Wray will describe what the FBI is doing to accomplish those goals. At the Department of Justice, our mandatory annual training will include lessons from the Inspector General's report, and we are considering other recommendations. We already revised the department's confidentiality policies to emphasize that non-public, sensitive information obtained in connection with our work is protected from disclosure. We intend to enforce that principle on our employees, and we need to demonstrate respect for it ourselves by protecting sensitive information entrusted to the FBI. A congressional oversight is vital to democracy. My June 27th letter, which I will submit for your consideration, explains how the executive branch handles congressional oversight requests for law enforcement and intelligence information. The FBI is managing an extraordinary volume of congressional oversight requests, some of which seek details about criminal investigations and intelligence sources. As a result of President Trump's commitment to transparency, the FBI is making unprecedented disclosures to the Congress, including granting access to hundreds of thousands of pages of investigative information and thousands of pages of classified documents. As with most things in Washington, the real work is not done on television, and it's not all done by me. Trump administration officials are meeting and talking with your staff every day. They're working overtime with teams of FBI employees to accommodate requests and produce relevant information to this committee, other House committees, and several Senate committees. This committee requested the production of all documents relevant to the Inspector General's review. As you well know, the FBI normally declines such requests. Because of the circumstances of this case and concerns that we developed during the investigation, the Department agreed to produce all relevant FBI documents. I understand that the universe of potentially relevant documents was in the range of 1.2 million, although only a fraction are actually relevant. We began the production even before the Inspector General finished his report, after we confirmed that the investigation was substantially complete and production at that time would not interfere with it. As you know, the FBI struggled for some time with the scope and volume of the production. Some of your colleagues brought to my attention that the FBI's redaction policies created the appearance that relevant information was being concealed. I looked into the issue and I understood their concern. As a result, I called on U.S. Attorney John Lausch from Chicago to take charge of the project. Mr. Lausch is here with me today, and I know he's talked with some of you in recent days. He's been working on this project for some time. Mr. Lausch brings experience in handling large document productions in the private sector. He worked with committee members and staff and arranged a production process that seems to be working very well. I understand that some people still state concerns about the speed of the production, but those concerns are mistaken. Most requests have been fulfilled, and other document productions are in progress for this committee and other committees. I have devoted almost 30 years to the service of my country. In my line of work, we keep an open mind, and we complete our investigations before we allege wrongdoing by anybody. Our allegations are made under oath and supported by credible evidence. And we treat everyone with respect and deal with one another in good faith. You and I are the beneficiaries and the temporary trustees of a remarkable experiment in self-government. Like each member of Congress, the Deputy Attorney General, the FBI Director, and other department officials represent the people of the United States. President Trump appointed us, the Senate confirmed our nominations, and we swore an oath when we accepted responsibility for helping to run the Department of Justice. That oath requires us to make controversial decisions. So here's the advice that I give to Department of Justice employees. Faithfully pursue the department's law enforcement mission and the administration's goals in a manner consistent with laws, regulations, policies, and principles. Be prepared to face criticism. That's part of the job. But ignore the tyranny of the news cycle, stick to the rule of law, and make honest decisions that will always withstand fair and objective review. Our department's 115,000 employees work diligently every day to keep America safe. Most of their good work is never the subject of any congressional hearing. It is a tremendous privilege to work in an organization that seeks the truth and serves the law. But the Department of Justice is not perfect. We will keep working to make it better, and we welcome your constructive assistance. Thank you.
Thank you, Deputy Attorney General. Director Wray, welcome. And
Thank you.
I want to thank you both for getting here. I know you've come a long way to get here and under difficult circumstances with an injury.
Thank you. Good morning, Mr. Chairman, members of the committee. I appreciate this opportunity to discuss the FBI's response to the Inspector General's report on DOJ and FBI activities in the run-up to the 2016 election. We take that report very seriously, and we accept its findings and its recommendations. We are already doing a whole number of things to address those recommendations, and we are determined to emerge from this experience better and wiser. The FBI is entrusted with a lot of authority, and our actions are appropriately, therefore, subject to close oversight. That oversight can make the FBI stronger and the public safer. Part of that oversight includes fulsome responses to legitimate oversight requests for documents and information. For months, we've been working with your committees to make witnesses available, answer questions, and produce or make available to you and your staff over now 880,000 pages. Although we have now substantially complied with a majority of the committee's subpoena, we are determined to get through the outstanding items, and we have increased staffing on this project even further. In just the past week, for example, we've had approximately 100 employees working day and night dedicated to this project through the weekend to collect, review, process, and produce thousands of additional pages. Turning to the IG's report, although the IG report did not find any evidence of political bias or improper consideration actually impacting the investigation under review, that report did identify errors of judgment, violations of or disregard for policy, and decisions that certainly, in the benefit of hindsight, were not the best choices. So I'd like to briefly summarize the steps we're taking to address the report's recommendations. First, we're going to be holding employees accountable for misconduct. We have already referred conduct highlighted in the report to the Office of Professional Responsibility, which is the FBI's independent disciplinary arm. And once the necessary process is complete, we will not hesitate to hold people strictly accountable. Second, we're making sure that every employee understands the lessons of the IG's report through in-depth training, starting at the top, starting with the executives, so we don't repeat mistakes identified in that report. Third, we're making sure that we have the policies, the procedures, and the training needed for everyone to understand and remember what is expected of all of us. That includes drilling home the importance of objectivity and of avoiding even the appearance of personal conflicts or political bias, ensuring that recusals are handled correctly, making all employees aware of our new media policy, which I issued last November, and making clear that we will not tolerate noncompliance with that policy, ensuring that we follow DOJ policies about public statements on ongoing investigations and uncharged conduct, and ensuring that we adhere strictly to all policies and procedures on the use of FBI systems, networks, and devices. I've also directed our new Associate Deputy Director, the number 3 official in the FBI, to lead a review of how we staff, structure, and supervise sensitive investigations so that we can make sure that each one is conducted to our highest standards. The IG report makes clear that we've got important work to do, but I do want to emphasize that this report is focused on a specific set of events in 2016 and a small number of employees connected with those events. Nothing in this report impugns the integrity of our workforce as a whole or the FBI as an institution. I want to be very clear with this committee about the FBI that I've gotten to see up close and personal in the 10 months since I've taken on this job. As I meet with our offices all over the world, offices represented by every one of the members up here on the dais, I encounter really remarkable, inspiring stories about the work our 37,000 men and women are doing every single day. We've rescued more than 1,300 kids from child predators this year alone. We've arrested more than 4,600 violent gang members in just the past few months. We've disrupted recently terrorist plots ranging from places like Fisherman's Wharf in San Francisco to a crowded shopping mall in Miami, and I could go on and on. Our men and women are doing all of that great work and much, much more with the unfailing fidelity to our Constitution and the laws that it demands, the bravery that it deserves, and the integrity that the American people rightly expect. That means we're going to do this job by the book. I am committed to doing that. I would not be here if I wasn't committed to making sure we do it that way, and I expect all our employees to do the same. That means following our rules, following our policies, following our longstanding norms. There will be times when we feel extraordinary pressure not to follow our process and policies, but in my view, those are precisely the times that we need to adhere to them the most. We've got to stay faithful to our best traditions and our core values, making sure that we're not only doing the right thing, but doing it in the right way, and pursuing the facts independently and objectively, no matter who likes it. That, in my view, is the only way we can maintain the trust and credibility of the people we serve. So, Mr. Chairman and members of the committee, thank you again for the opportunity to address the Inspector General's report, and I look forward to answering the committee's questions.
Thank you, Director Wray. We'll now proceed under the 5-minute rule with questions, and I'll begin by recognizing the gentleman from Florida, Mr. DeSantis.
Thank you, Mr. Chairman. Welcome to the witnesses. Mr. Rosenstein, August 8th, 2016, text message in the IG report from Lisa Page to Peter Strzok. Trump's not ever going to become president, right? Right? Peter Strzok responds, no, he's not. We'll stop it. Now, the Justice Department had previously provided text messages from that date. They included all the messages we now have except the "we'll stop it" text message. Why didn't the Justice Department produce that to Congress when we asked?
Mr. DeSantis, I spoke with our Inspector General, Michael Horowitz, yesterday, and he told me that when he testified, he didn't have a full opportunity to explain, and the technological details are pretty complicated, but he assured me he had had a long telephone conversation with Mr. Jordan after the hearing and explained it. He's much better positioned than I. What I can assure you...
So let me just ask this then.
If I could just explain, sir, I want to assure you and the American people, we're not withholding anything embarrassing. The message was not in the original material that the Inspector General, he found these messages?
Right, so you guys didn't find it, and he did. And so we're asking you to produce stuff, and obviously, we're expecting a good faith effort. You guys didn't find it, and maybe somebody else deleted it or something happened before you guys, but he was able to find it and you didn't. So it was very disappointing to see that text message there, because I think you would agree. Just think of the timeline here. You have Peter Strzok. He opens up the counterintelligence investigation against Trump's campaign at the end of July. Then a week later, this text message, he ain't going to be president, we'll stop it. Then the next week, the infamous insurance policy text message where he says, we can't take the risk of a Trump presidency, you need an insurance policy. The American people see that. Doesn't that undermine the whole integrity of the actions of people like Peter Strzok?
Yes, Congressman, that obviously is highly inappropriate. And
well, it's more than that, though.
It's
more than that. I mean, the Inspector General did find that the bias affected. He didn't say it affected the decision about Hillary, but he said once we got into the fall, when you had the Huma Abedin emails and there was slow walking on that by Peter Strzok, he was really concerned with pursuing this collusion investigation. And he testified on the record that it was absolutely reasonable to say that the bias not only existed, but affected what he did. Let me ask you this. What did the DOJ or FBI do in terms of collecting information, spying, or surveillance on the Trump campaign, be it via Stefan Halper or anybody else working on behalf of the agencies?
As you know, Congressman, I'm not permitted to discuss any classified information in an open setting, but I can assure you that we are working with oversight committees and we're producing all relevant evidence that will allow them to answer those questions.
Let me ask you this then. Did the Obama administration, anybody in the administration, direct anybody, Halper or anybody else, to make contact with anyone associated with the Trump campaign?
As I said, Congressman, I appreciate, obviously, I understand your interest, but I'm not permitted to discuss classified information.
Well, we want the documents, so I know we're in a back and forth on that, but the American people need to know were the counterintelligence powers of the Obama administration unleashed against Trump's campaign. If that was done, was it done inappropriate? Let me ask you this. They talk about the Mueller investigation. It's really the Rosenstein investigation. You appointed Mueller. You're supervising Mueller. And it's supposedly about collusion between Trump's campaign and Russia and obstruction of justice. But you wrote the memo saying that Comey should be fired. And you signed the FISA extension for Carter Page. So my question is to you, it seems like you should be recused from this more so than Jeff Sessions, just because you were involved in making decisions affecting both prongs of this investigation. Why haven't you done that?
Congressman, I can assure you that if it were appropriate for me to recuse, I'd be more than happy to do so and let somebody else handle this, but it's my responsibility to do it. And all I can tell you is
then how do you have obstruction of justice possibility for a president exercising his powers to fire an FBI director that you said should be fired? And oh, by the way, the IG report makes it clear Jim Comey should have been fired. So why are we still doing this with the Mueller probe?
Sir, I am not commenting on what is under investigation by the Mueller probe, and to the best of my knowledge, neither is Mr. Mueller. I know there's a lot of speculation in the media about that, but that doesn't relieve me of my obligation not to discuss the subject matter of the investigation.
Do you accept what IG Horowitz said regarding Peter Strzok and the fall campaign with Huma Abedin emails, how he slow-walked that versus how he was so gung-ho about the Trump-Russia collusion? Remember, he texted Lisa Page. The other thing, Hillary mattered because we didn't want to mess it up, but this matters because it matters. That's what he wanted to do, and that's where he was focusing his energy on. Horowitz said his bias is an appropriate explanation for his conduct. Do you agree?
I certainly agree with the findings of the Inspector General report, and I think those messages clearly do indicate bias.
Well, you guys have some work to do, because if the bias is affecting official action, that is a big, big problem. I yield back the balance of my time.
The chair recognizes the gentlewoman from California, Ms. Lofgren, for 5 minutes.
Deputy Attorney General Rosenstein and Director Wray, this may be an appropriate time to make what is kind of an easy request, but could you state for the record what is the Department of Justice and Federal Bureau of Investigation's policy on commenting on any matter related to an ongoing criminal or counterintelligence investigation? And does this policy apply to document production even when requested by Congress?
Yes, Congresswoman. Director Wray may be able to speak more specifically to the reasons why the FBI doesn't comment on counterintelligence investigations, but we do not discuss counterintelligence investigations or criminal investigations while they're ongoing.
Congresswoman, it's always been my experience that the Department and the FBI do not comment on ongoing investigations. There are a number of reasons for that that go back to all the days when I was a line prosecutor, and long, long before that. They have to do with protecting the reputations and the privacy of the people who are subject to the investigation. They have to do with protecting the integrity of the ongoing investigation. They have to do with protecting the rights to fair trial when that's relevant, and there are a whole number of reasons. And when you add the counterintelligence dimension, there's the need to protect sources and methods. And one of the central learnings of the Inspector General's report, frankly, that we're here talking about with this committee is about what goes wrong when you do talk about ongoing investigations.
So these policies apply to all current and former personnel at DOJ and the FBI, as well as to the special counsel investigation, correct?
That's correct.
Thank you. You know, it seems to me, I mentioned this the other day, that we are here pursuing release of information that, in my experience on this committee, 24 years on this committee and 9 years as a member of this staff of one of the members of the committee, that I've never seen this happen before. And having been given the opportunity, along with just Mr. Nadler, Mr. Goodlatte, and Mr. Gowdy, to actually read the entire application on the Carter page, the FISA application, along with the accompanying documents, took me all day. I mean, I canceled all my appointments. It's very obvious why that material should not be in the public arena. There are people, I think, who would certainly could lose their lives if their identities were made known. And it's an example of the requirement that you labor under, but also that the committee labors under. I want to mention, and Mr. Jordan is here, so he'll correct me if my understanding is incorrect, but I understand Mr. Jordan accused you, Mr. Rosenstein, on the floor during debate of threatening the HPSI staff if they attempt to hold you in contempt for failing to comply with document requests. And I think it's important we put this on the record. Have you, Mr. Rosenstein, ever threatened congressional staff, including but not limited to House Intelligence Committee staff, as it relates to requests for your for you to produce documents or any other matter for that.
Congresswoman, people make all kinds of allegations. And in my business, we ask, who's the witness and how credible are they? And if somebody comes forward and swears under oath that I threaten them, then I'll be happy to respond. All I can tell you with regard to that matter is that in the room at the time were 3 officials appointed by President Trump and confirmed by the United States Senate, Director Wray, Assistant Attorney General Boyd, and me. 2 former Republican U.S. attorneys were also in the room with us, Greg Brower, who at the time was serving as the legislative liaison for the FBI, and Scott Schools.
So your answer is no.
The answer is no, I have not threatened anyone.
Thank you very much. I just would like to close with this as my time is running out. It just seems to me that we are asking you to violate the policies that you labor under, and we've been doing that repeatedly. We've got the 500-page IG report. You've acknowledged the needs to improve areas. Last week we held a 6-hour hearing. Yesterday, 11 hours trying to get the FBI to violate the same policies that you are upholding today. And I think it's really not what this committee should be doing. I do not believe it is in the best interest of this country, and certainly it does not uphold and elevate the rule of law, which is what this committee should be doing and has been doing for the quarter century that I've served on it. And I yield back, Mr. Chairman.
The chair recognizes the gentleman from Florida, Mr. Gates, for 5 minutes.
Thank you, Mr. Chairman. Director Wray, I am in violent agreement with the statements you made after this report was published, that nothing in the report impugns the patriotic work of the FBI employees who are serving in my district and around the world. And this mess in Washington has nothing to do with them, and I want to make that very clear. And I appreciate your statements on that subject. Deputy Director, the Democratic memo that the President declassified says the Department of Justice accurately informed the court that the FBI initiated its counterintelligence investigation on July 31st, 2016. Did any investigative activity regarding the Trump campaign in Russia occur before July 31st, 2016?
Congressman, as you know, we're dealing with the Intelligence Committee on that issue, and Chairman Nunes met with Director Wray and me. I received the same briefing that he received. So I don't know any additional information beyond what he knows about that, and I'm not able to produce any information beyond what the FBI has told me. So,
are you aware, as you sit here today, of any payments that were made to any person to collect intelligence on the Trump campaign prior to July 31st, 2016?
No, but keep in mind I wasn't there. I only know what information that we've obtained from the FBI records.
Are you, as you sit here today, aware of any efforts to contact Roger Stone that occurred prior to July 31st, 2016?
I don't have any personal knowledge, Congressman, but I know that we are seeking to respond to Chairman Nunes' request. I think one thing you need to understand...
Same question as it regards to Michael Caputo.
I wasn't there, and so I can only answer questions that we direct to the FBI and then have them...
You're there now, right? I mean, have you asked these questions of anyone?
We have absolutely conveyed all the questions that Chairman Nunes has raised, and I'm optimistic that we'll be able to respond to him fairly soon.
You could understand why it would be of tremendous importance to the country that if the Department of Justice has represented to a court that this investigation began on July 31st, and if the fact that you cannot tell me definitively that before July 31st there was not intelligence collected on the Trump campaign, that is something of great interest to us.
Congressman, I think you should understand that there is nobody more committed to rooting out abuse and misconduct than I. We talk with the FBI, we take those allegations seriously, and we look to find any credible evidence. And if we find it, we're going to produce it to Chairman Nunes.
Thank you. Let's do that quickly. And let's get into your determination to find out that activity which is occurring in your department. At the last hearing we had, I asked you when you first became aware that Nellie Orr, the wife of your Associate Deputy Attorney General Bruce Orr, was working for Fusion GPS and was actively assigned to the dossier that said all these nasty things about President Trump. As you sit here today, do you know when you became first aware of that?
I believe it would have been sometime in the fall of 2017. As I think I told you last time, Mr. Orr was never working, to my knowledge, on that Russia investigation.
Well, his wife was, right? I mean, like, right. He's your assistant or your associate deputy attorney general, and his wife gets hired for that. I asked you this question on the 13th of December. I wrote you a letter on the 18th of December, 9 months ago. You have not responded to it. We need a date when you found out that the wife of your deputy was working for people who are actively trying to undermine President Trump. Don't you think that's a really important date for you to know about the spouse of your own Associate Deputy Attorney General?
Yes, I think it's important for you to understand, Congressman, Mr. Orr is a career employee of the department. He was there when I arrived. To my knowledge, he wasn't working on the Russia matter.
I don't care if he's there 100
Well, I think it's important for you to know, sir, that when we learned the relevant information, we arranged to transfer Mr. Orr to a different office.
Let's get to
and in addition to that, sir,
hold on, I'm sorry, I got to reclaim my time, Mr. Rosenstein. The FISA renewal that you signed, list for me the people who briefed you on the substance of that FISA renewal to go and spy on people.
So, Mr. Gates, here's one thing I think is important for you to understand. People can make all kinds of allegations publicly. I am quite confident about my conduct throughout this investigation. That matter is under review by the Inspector General. We'll see what the Inspector General finds.
Did you read the FISA application before you signed it?
I'm not going to comment about any FISA application.
So you won't say to this committee whether or not you even read the document you signed that authorized spying on people associated with the Trump campaign?
Well, I dispute your characterization of what that FISA is about, sir.
Did you read it or did you not read it?
I'll be happy to review. I'll be happy to discuss the details with you. But as I told you, sir.
Did Peter Strzok brief you on it?
No.
Did Lisa Page brief you on it?
No.
Did Sally Moyer brief you on it?
Now, let me explain the process, if I may.
Well, did Tricia Anderson brief you on it?
No FBI personnel briefed me on it. The process, sir, is that these FISA applications and renewals first come up through the FBI chain of command. They are sworn under oath by a career federal agent. I'm not the affiant.
But you signed it.
I'll explain the process to you.
Did you thoroughly review it, yes or no?
I want to explain the process to you.
I'm out of time. Did you thoroughly review it?
The time of the gentleman has expired. The witness will be permitted to answer the question.
I'd like to explain the process. Director Wray can explain it too, sir. My responsibility at that time was to approve the filing of FISA applications because only 3 people in the department are authorized to be the final sign-off, the Attorney General, the Deputy, and the Assistant Attorney General for National Security, who at the time that position was vacant. So it's my responsibility to do that. I have fortunately been relieved of that responsibility. Director Wray still does it every day. And I don't know exactly what his process is, sir, but we sit down with a team of attorneys from the Department of Justice, all of whom review that, provide a briefing for us about what's in it. And, sir, I've reviewed that one in some detail. And I can tell you, sir, that the information that's public about that doesn't match with my understanding of the one that I signed. But I think it's appropriate to let the Inspector General complete that investigation. These are serious allegations. And I don't do the investigation. I'm not the affiant. I'm reviewing the finished product, sir.
Are they investigating you?
If the Inspector General finds that I did something wrong, then I'll respect that judgment. But I think it's highly, highly unlikely, sir, given the way the process works.
Yield back.
Chair recognizes the gentlewoman from Texas, Ms. Jackson Lee, for 5 minutes.
Mr. Chairman, thank you very much. And let me thank ranking member who remains on the floor. I know he's en route. I'm almost believing that I've just attended or I'm in the midst of a monster ball. And we're looking for monsters wherever we can find them. As I was on the floor, I heard someone say, Mr. Deputy Attorney General, that they're interested in holding you in contempt. Maybe they may be mollified by a resolution that really has no real point to it. But this is the absurdity that we are dealing with in an investigation that has proceeded and I believe has concluded. So let me ask you, 2 investigations that were ongoing in 2016, could you just very briefly say what they were? 2 investigations regarding presidential candidates. What were those investigations?
Congressman,
Mrs. Clinton, what was the investigation for Mrs. Clinton?
I'm not going to comment on any investigation that may have been ongoing. I know there's a lot of publicity about it, but I'm not going to comment on it.
All right, can you comment on the IG report? What was the IG report about?
Yes, the IG report is about, actually it's about a variety of misconduct that occurred in the FBI in 2016 and 2017.
Relating to?
Relating to, well, it's primarily focused on the Hillary Clinton email investigation, but the Inspector General actually addressed a few other issues in that report as well.
Did that investigation come to a conclusion in 2016, to your knowledge?
The Hillary Clinton email investigation?
Yes.
Well, it did, based upon public reports.
And based upon public reports, was the Department of Justice satisfied with those, the end of that investigation?
Congresswoman, I have the same response I had to Mr. Gates. I wasn't there, and I'm not the one to comment on whether or not people were satisfied with the result. We all know what the result was.
Director Wray, your agents were involved in the FBI investigation of the Clinton emails. Is that accurate?
Yes, obviously I was not there at the time, but yeah, absolutely.
You've had a chance to review the Inspector General's report?
I have.
And saw the fractions that were cited to the FBI?
I'm sorry, the
fractions, the infractions support.
Oh, the infractions, yes, yes.
Have you corrected, or do you have a comment on any of the infractions which you corrected, i.e. Director speaking about an investigation without the presence or yielding to one of the prosecutors of the DOJ, such as what Director Comey did?
Well, Congresswoman, I'm not going to add my own personal opinion on top of the Inspector General's very thorough report, but we, as I said earlier, we do accept the findings that are in the report and the recommendations in it, and I will say that...
What have you done with respect to the recommendation about the idea of a director of the FBI making such statements going forward?
So we've done a couple of things. One is that we have issued a new media policy that is much more clear so that we ensure that people follow our policies. We've also directed people to make sure that they're adhering to DOJ policies about commenting on ongoing investigations and specifically about uncharged conduct.
From the law enforcement perspective, which is what your arm is.
Correct.
Is that correct?
We're not the prosecutors.
Thank you. Do you have any comment on the suggestion that one of your officers delayed in investigating the Wiener laptop? Do you think that was done to undermine the investigation?
Well, Congresswoman, again, I think rather than substitute my characterization for the Inspector General's, which is very detailed, I would just say that my read of the Inspector General's report is that he found that there were delays as a result of a number of factors. And we are taking steps to make sure that going forward, as I said in my opening comments, that we structure, staff, and supervise sensitive investigations in an appropriate way so that we don't repeat any of the mistakes that are reflected.
And looking back, do you think that impeded or impacted on the final conclusion of the Clinton email investigation?
Well, again, I would defer to the Inspector General's own characterization of his investigation. My understanding of it is that he found that there was no political bias ultimately impacting the investigation that he reviewed.
Mr. Attorney General, do you believe, as Donald Trump indicated, that the investigation of which you have read, the Inspector General's report, has vindicated Mr. Trump as relates to collusion with Russian agents, as he indicated? Or is the investigation ongoing?
There is an ongoing investigation, yes.
And it's not concluded?
Correct.
And no conclusion has been made on any aspect of the investigation today?
Well, there have been several charges that have been filed, and so you're familiar with those.
Correct.
The gentlewoman
it's ongoing. Thank you. I yield back.
The chair recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. The Russia investigation has been going on for almost 2 years now. Special counsel's investigation has been going on for over a year now. For most Americans, it's important to know what Russia did to our country in 2016 and with whom, if anyone, they did it. When a foreign state interferes with our democratic electoral process, it should be a chance of a lifetime for a law enforcement agent to investigate that, except apparently the one that was actually picked to investigate it. That was Peter Strzok. FBI agent Peter Strzok was picked to lead the FBI's investigation into what Russia did in July of 2016. It was a counterintelligence investigation begun in late July 2016, and he was leading it. And at about the exact same time he was picked to lead it, this dispassionate and fair FBI agent was calling Trump a disaster, destabilizing for the country. I'll leave out all the adjectives he used to describe that. I'll just go with disaster and destabilizing. Same time, his FBI lawyer girlfriend, Lisa Page, was telling him he was meant to protect the country, This neutral, dispassionate FBI agent said, I can protect the country at many levels. Same time, Peter Strzok, who was picked to objectively, fairly, neutrally look into the Russia investigation, was talking about an insurance policy with Andy McCabe and Lisa Page in the event Donald Trump became the president. All of this was happening at the same time Peter Strzok said he could smell the Trump support in Southern Virginia. All this was at the same time that this FBI agent said a Trump presidency would be effing terrifying and that it will never happen. No, we'll stop it. So while investigating Russia and their attempt to subvert our democracy may have been important to the rest of the country, it wasn't all that important to about a half dozen FBI agents and lawyers who were assigned to the case. For them, it was an investigation to stop Donald Trump, which then brings us to May of 2017 and the appointment of special counsel, where we find Peter Strzok again, this same supposed to be dispassionate, neutral, fair FBI agent. You would think he'd be really excited about investigating what a foreign power tried to do to this country, but you would be wrong again for Peter Strzok at precisely the same time that Bob Mueller was appointed, precisely the same time. Peter Strzok was talking about his unfinished business and how he needed to fix and finish it so Donald Trump did not become president. He was talking about impeachment within 3 days of special counsel Mueller being appointed. 3 days. That's even quicker than MSNBC and the Democrats were talking about impeaching him. Within 3 days, the lead FBI agent is talking about impeaching the president. So this is where we are. We're 2 years into this investigation. We're a year and a half into the presidency. We're over a year into special counsel. You have a counterintelligence investigation that's become public. You have a criminal investigation that's become political. You have more bias than I have ever seen manifest in a law enforcement officer in the 20 years I used to do it for a living. And 4 other DOJ employees who had manifest animus towards the person they were supposed to be neutrally and detachedly investigating. Democrats are using this investigation as a presumption of guilt, which I find astonishing, and in the long run for the health of this republic, I would encourage them to go back to the presumption of innocence that we used to hold sacred. There's a presumption of guilt. There's a desire by Democrat senators to fundraise off of your investigation. More than 60 Democrats have already voted to proceed with impeachment before Bob Mueller has found a single solitary damn thing. More than 60 have voted to move forward with impeachment, and he hasn't presented his first finding. So I'm going to say this to you, Mr. Ray, Mr. Rosenstein. I realize that neither one of you were there when this happened, but you're both there now. Russia attacked this country. They should be the target, but Russia isn't being hurt by this investigation right now. We are. This country is being hurt by it. We are being divided. We've seen the bias. We've seen the bias. We need to see the evidence. If you have evidence of wrongdoing by any member of the Trump campaign, present it to the damn grand jury. If you have evidence that this president acted inappropriately, present it to the American people. There's an old saying that justice delayed is justice denied. I think right now all of us are being denied. Whatever you got, finish it the hell up, because this country is being torn apart. I would yield back, Mr. Chairman.
Either of the witnesses care to respond to the...
Well, I would simply respond, Ms. Gowdy. I certainly share your views about those text messages, and nobody is more offended than I about what's reflected in those messages. With regard to the investigation, I've heard suggestions that we should just close the investigation. I think the best thing we can do is finish it appropriately and reach a conclusion. And I certainly agree with you, sir, that people should not jump to conclusions without seeing the evidence. I've been the victim of fake news attacks myself, so I'm sympathetic. I agree with you, sir, that there's been no allegation made by the Department of Justice or the special counsel other than what's reflected in those documents that are filed publicly, the charged folks. And nobody should draw any conclusions beyond those charges.
The chair recognizes the gentleman from Tennessee, Mr. Cohen, for 5 minutes.
Thank you. Director Ray,
Mr. Rosenstein, was Peter Strzok the head of any of those investigations?
Well, Congressman, I don't know that I would characterize him as the head of any of the investigations. Certainly, he played a significant role in the investigations that are described in the Inspector General's report, but there was a supervisory chain, and as the Inspector General found, there were a number of people involved in that chain above him.
And I know you've spoken already about the Inspector General's report. It's very thorough, and you accepted it. It came to the conclusion that while he may have had biases, none of his biases played a role in their actions or their conclusions. Is that correct?
Well, again, I would defer to the Inspector General's own characterization of his very thorough investigation, but my understanding of it is that he found no evidence of political bias actually impacting the investigation that he reviewed.
So all we had was some talk between friends, maybe lovers, and it was just talk, but no policy and no action to bring about or effectuate any of their beliefs, correct?
Well, again, I don't know that I want to start characterizing their text messages. I expect all our folks to conduct themselves professionally at all times, and the other reason I want to be careful about straying too far is that, as I said in my opening, we have referred a number of individuals whose conduct is highlighted in the report to our Office of Professional Responsibility, and my commitment to doing things by the book includes making sure that our disciplinary process is done by the book, and having the director comment on their conduct in this setting is probably not conducive to that.
Thank you, sir. Am I correct that each of you were appointed by President Trump? Is that correct?
Yes, sir.
Yes.
And who appointed the special counsel?
I did.
And you were appointed by President Trump?
Correct.
Now, President Trump talks about 13 Democrats running this investigation. Do you know who he's speaking about, and if there's any way that the Justice Department or President Trump knows if these people are Democrats, Republicans, Libertarians, Bolsheviks?
You have to ask him, sir. I do not know.
But you don't know if they're Democrats?
I do not know their political registration, no, sir.
Director Wray, do you know any of these people's political registrations?
I'm not familiar with their political registration, no.
Thank you. This report, the special counsel has gone on for a long time. Could that be because there is so much information and so many issues that have arisen from his investigation that it's impossible to just turn it off? Is that possible, Mr. Rosenstein?
I do not think you should draw any inference. I don't think, as these sort of investigations go, that it's actually been going on for a long time, and I can assure you that Director Mueller understands that I want him to conclude it as expeditiously as possible, consistent with his responsibility to do it right.
Has anybody ever accused Director Mueller, Special Counsel Mueller, excuse me, of being dilatory, lazy, slow?
I certainly haven't, sir. I don't know what other allegations people make, but I certainly do not view that as accurate.
Director Wray, do you know Special Counsel Mueller's reputation for promptly doing his work and proceeding in a diligent path?
My own experience and familiarity with Director Mueller is that none of those adjectives would describe to much of anything he's done in his career for this country.
Director Mueller, as I remembered, volunteered to join the Marines in Vietnam, got a Purple Heart and had other commendations. Is that what you understand too?
Yes, sir.
And then when he came back, he went to law school and he went to work for justice. He could have gone to Wall Street and made a lot of money. In fact, he went into private practice for a while, but he didn't like it. And he came back because he wanted to prosecute criminals. Is that correct?
Well, I don't know his motivation, but I do know he's devoted much of his career to public service and has foregone more lucrative opportunities.
And he prosecuted Manuel Noriega, did he not?
Congressman, I'm not certain whether he was, I think he was in a management position. I don't know if he personally prosecuted it, but I think that's correct.
And John Gotti?
I don't know the answer to that, sir.
Well, he's gone after big fish. Let me ask each of you to promise me something. Will you promise me and the American people that no matter what pressure is brought about and brought on you by whomever, that you will stay in your position and finish the job and do what you were appointed to do and what the American people need you to do?
Congressman, in the Department of Justice, we're accustomed to criticism, and it does not affect our work.
Congressman, as I've said repeatedly, I am committed to doing this job by the book in all respects, and there's no amount of political pressure that's going to dissuade me from that by either side.
Thank you. And I find you and each of you and Special Counsel Mueller as paragons and people who should be revered and not torn down, and people who tear them down, tear down the flag and tear down the American government. I yield back and hope the Constitution is respected.
The time of the gentleman has expired. The chair recognizes the gentleman from Ohio, Mr. Jordan.
Thank you, Mr. Chairman. Mr. Rosenstein, why are you keeping information from Congress?
Congressman, I am not keeping any information from Congress that it's appropriate.
In a few minutes, Mr. Rosenstein, I think the House of Representatives is going to say something different.
I don't agree with you, Congressman. I don't believe that's what they're going to say, and if they do, they'll be mistaken.
I disagree, but I think in a few minutes, the House of Representatives is going to go on record saying you haven't complied with requests from a separate and equal branch of government, that you haven't complied with subpoenas, and you got 7 days to get your act together. I think that's what's going to happen in a few. And that's not Jim Jordan. I think that's a majority of the House of Representatives. In just a few minutes, I think that's going to happen. And I want to know why you won't give us what we've asked for.
Sir, I certainly hope that your colleagues are not under that impression. That is not accurate, sir. And
it is accurate. We have caught you hiding
Mr.
information,
Chairman, can we allow the witness to
Rosenstein.
answer? Mr. Chairman, point of order. We can go to Mr. Jordan's press conference and listen to him, but we came here to hear from the witnesses.
The time belongs to the gentleman.
Mr. Rosenstein,
can we allow him to answer?
We have caught you hiding information.
We're going to allow him to answer.
He will be permitted to answer when Mr. Jordan.
Why do we have them here?
We'll allow him additional
Rosenstein
time to answer.
Why are they not allowed to answer?
The gentleman's out of order. The gentleman from Ohio is recognized.
Mr. Rose, let me make this one point, then I'll let you answer.
Mr. Jordan, I'd like to
let me make this one point,
sir.
where we've caught you
answer
hiding
the
information, then
sir?
you can answer. Why did you hide the fact that Peter Strzok and Judge Contreras were friends? Why did you redact that in the documents you gave to us? Judge Contreras is kind of important. FISA court judge, more importantly, just as importantly, the judge that heard Mike Flynn's case. Why did you try to hide that from us?
Mr. Jordan, I appreciate you giving me the opportunity to respond. I've heard you make those sort of allegations publicly on TV.
I got
and if you let me respond, sir.
Mr. Chairman, he should be given
Right
the
here.
opportunity.
Now, Mr. Jordan,
answer.
It's redacted.
I am the Deputy Attorney General of the United States. Okay? I'm not the person doing the redacting. I'm responsible for responding to your concerns as I have. I have a team with me, sir. It's just a fraction of the team that's doing this work, and whenever you brought issues to my attention, I have taken appropriate steps to remedy them. So your statement that I'm personally keeping information from you, trying to conceal information
You're
from
the boss, Mr. Rosenstein.
not true. That's correct. And my job is to make sure that we respond to your concerns. We have, sir. Now, I've appointed Mr. Lausch, who is managing that production, and my understanding is it's actually going very well, sir. So I appreciate your concerns.
Again, I think the House of Representatives is going to say otherwise.
But your use of this to attack me personally
Why did you?
is
It's not
deeply wrong.
Point of order, Mr. Chairman. May the witness be permitted to answer the question?
It's not personal.
The gentleman will suspend. The witness is going to have an opportunity to say whatever he wants at the end of Mr. Jordan's 5 minutes. Until the
it is
end
not
of those
personal.
5 minutes, they're his time.
I appreciate your service. It's not personal. We just want the information. Why did you tell Peter Strzok not to answer our questions yesterday? When I asked Peter Strzok if he'd ever communicated with Glenn Simpson, he gave us the answer he gave us dozens of times. On advice of FBI counsel, I can't answer that question. Why couldn't he answer that question?
Mr. Jordan, I appreciate your sincere concerns, but I didn't give Peter Strzok any instructions. If there was some problem with the instructions he had, I'll be happy to look into it.
Not what his
You have to
FBI lawyer said.
understand, Mr. Jordan, when you find some problem with a production or with questions, it doesn't mean that I'm personally trying to conceal something from you. It means we're running an organization that's trying to follow the rules, and we're going to respond.
You know what was interesting? When I asked him if he'd ever talked to Bruce Orr, he said he had. Said he had 3 times in 2016 and 2017. Then I asked him, have you ever talked to Nellie Orr? And he said, no, I haven't. I said, well, why can you answer that question? Because Nellie Orr worked for Glenn Simpson, worked for Fusion. He could answer that question, but he couldn't answer because FBI counsel told him he couldn't. He couldn't answer the question whether he'd ever communicated with Glenn Simpson, a journalist. Why couldn't he answer that question?
Mr. Jordan, I appreciate you saying it isn't personal. Sometimes it feels that way. How do I know, sir? I mean, you interviewed Mr. Strzok. I didn't, so I can't
Works for
answer.
you. Doesn't work for us.
There are 115,000 people who work for me, sir.
Mr. Rosenstein, did you threaten staffers on the House Intelligence Committee? Media reports indicate you did.
Media reports are mistaken.
Sometimes. But this is what they said. Having the nation's #1 law enforcement officer threatened to subpoena your calls and emails is downright chilling. Did you threaten to subpoena their calls and emails?
No, sir, and there's no way to subpoena phone calls.
Well, I mean, I'm just saying. I'm reading what the press said. I'm reading what the press said.
I would suggest that you not rely on what the press says, sir.
Well, I didn't ask if there's no way to do it. I asked if you said it.
If I said what?
What I just read you.
No, I did not.
Well, now who are we supposed to believe? Staff members who we've worked with, who've never misled us, or you guys who we've caught hiding information from us, who tell a witness not to answer our questions? Who are we supposed to believe?
Thank you for making clear it's not personal, Mr. Jordan.
Well, I'm saying the Department of Justice.
Me because I'm telling the truth and I'm under oath. And if you want to put somebody else under oath and they have something different,
I know these staff members.
Respond.
Here's my last question. What's so important that you know that you don't want us to know, that you won't give us the documents we're asking for, that the House of Representatives is about ready to go on record saying you should give us? What's so darn important that you will threaten members, at least according to media reports and according to the staff members, threaten members?
Parliamentary inquiry, Mr. Chairman.
What is so important, Mr. Rosenstein?
Parliamentary inquiry, Mr. Chairman.
This is not an appropriate time for a parliamentary inquiry.
And point of order. The gentleman keeps representing that the House of Representatives, yes, it will be, the Republicans who continue
that is not an appropriate point of order.
Well, he needs to be corrected in his statement.
The time of the gentleman
will
be
be
restored.
the members of the Republican Party.
The gentleman will suspend. The time of the gentleman from Ohio will be restored for another additional 15 seconds, and then the Deputy Attorney General will be allowed to respond.
Thank you, Mr. Chair. Mr. Rosenstein, Mr. Ray, I do appreciate your work, but I'd also appreciate if the House of Representatives could get the information. We have repeatedly, Mr. Gowdy talked about how long this investigation is going on, how long there's been a special counsel. We started asking for information in July of last year, and some of that is still has not been given to the Congress, still has been given to this committee, the committee charged with defending the Judiciary Committee. So I appreciate what you do. I just want the information, and we're so frustrated that there is now a resolution on the floor of the House in just a few minutes that will be voted on.
The time of the gentleman has expired. Mr. Rosenstein will be allowed to respond.
I don't have any control over what resolutions you vote on, sir, and
I know
feel free to do that.
The gentleman will suspend it. The time now is the Attorney General's.
If you're interested in the truth, Mr. Jordan, the truth is we have a team of folks, they're Trump appointees and career folks, and they're doing their best to produce these documents. Director Wray explained to you the process. He's got hundreds of people working around the clock trying to satisfy these requests. So whether you vote or not is not going to affect it. You're going to get everything that's relevant that we can find and produce to you. I support this report, sir. I'm not trying to hide anything from you.
The chair recognizes the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Vote.
Oh, okay. All right. Thank you. Gentlemen, I appreciate your service. I've been impressed with your diligence and your honesty and your integrity in this very difficult environment that we find ourselves in. And basically, it's a situation where the majority is hurting this country. We're hurting our country with what we're doing today. What we're doing today is holding an emergency hearing, a so-called emergency hearing based on allegations that political influence or political bias within the FBI and the DOJ has somehow led to a illegitimate result in the Hillary Clinton email investigation. That's an investigation that was conducted originally. It was conducted by the FBI, DOJ, no criminal charges filed, investigation closed. Then there was a Inspector General's investigation of that investigation. Those reports, or that report was issued last week. It found that there was no wrongdoing in the investigation of the investigation. And now today we have an investigation of the investigation of the investigation, and it's a emergency situation. Also a part of this hearing is a attempt to investigate the ongoing criminal investigation into the allegations and indications of collusion and perhaps conspiracy with Russians in the conducting of the 2016 presidential election. And ominously, what the Republicans are trying to do is force the FBI and DOJ to turn over to this committee investigating the investigators information, documents that go to the heart of the criminal investigation. It's been my experience that the criminal investigators never turn over information. They're never even asked to turn over information in an ongoing criminal investigation. Can you both comment on the uniqueness of what's happening today and the danger that it poses to justice in this country?
Congressman, I don't believe it poses any danger because we are not going to produce any documents that will interfere with an ongoing investigation. Well, as I said, in response to Mr. Jordan's question, we actually are producing the documents. It's a large volume of documents. It's taking a lot of time. And as I said, I thought he had a legitimate point about the redactions that made it appear as if the Bureau was concealing information. So we brought in Mr. Lausch. We changed the process. And I actually think, in reality, it's working quite well. Whatever anybody votes on is beyond my control.
Well, go ahead.
Congressman, we are committed to being responsive to legitimate congressional oversight. We're trying our hardest to produce documents as quickly as we possibly can and as completely as we possibly can. We also have an obligation to protect ongoing criminal and counterintelligence investigations. We also have an obligation to respect grand jury secrecy. We also have an obligation to protect sources and methods. And we're sworn to do those things just like we are to protect and be responsive to congressional oversight. And the Inspector General's report, ironically, the report that we're here to talk about, is very pointed on the subject as one of the principal failings that it found was commenting on an ongoing investigation publicly and with Congress. And so we take those lessons very seriously. We're trying to learn those lessons.
Well, Director Wray, threatening you with a subpoena, threatening you with contempt of Congress for noncompliance with a congressional subpoena puts you in a bad position, doesn't it?
Well, certainly when I was minding my own business in private practice in Atlanta, I didn't think I was going to be spending the first 10 months of my job staring down the barrel of a contempt citation for conduct that occurred long before I even thought about being FBI director. Having said that, I am committed to making sure that we're responsive to these committees. And to the extent that we can do better, we're trying to do better.
Well, there's certain information.
But at the same time, in my experience, there are two principles that have to be balanced. Responsiveness to congressional oversight, which is very important to me personally, but also respecting ongoing criminal investigations, which is also very important.
And there's certain information that you cannot provide to this committee based on the ongoing nature of the criminal investigation. Is that correct?
Yes.
The time of the gentleman has expired. The committee will stand in recess. There's 6 minutes and 45 seconds remaining in a vote on the floor, and we will reconvene as soon as that vote concludes.
Appreciate it. Couldn't hear you. What? Oh, gotcha. Okay.
More testimony now from FBI Director Christopher Wray and Deputy Attorney General Rod Rosenstein on the Clinton email probe. This is 2 hours and 10 minutes.
The committee will reconvene, and the chair recognizes the gentleman from Texas, Mr. Ratcliffe, for 5 minutes.
Gentlemen, Agent Peter Strzok gave us the timeline yesterday that following his work on the Hillary Clinton email investigation, he was assigned as lead agent of the Russia collusion investigation from late July of 2016 until May of 2017. Then in late May of 2017, following your appointment of Robert Mueller, Agent Strzok became part of Special Counsel Mueller's investigative team until late July of 2017 when he was removed by Special Counsel Mueller and returned to the FBI. Any disagreement about that timeline?
I don't know the precise dates, but that sounds generally accurate.
During 11 hours of testimony yesterday, Agent Strzok testified at length about his roles during that year from late July of 2016 to late July of 2017 as part of those investigative teams. He testified, in fact, that he drafted the initial investigative plan on the Russia collusion investigation, that he made investigative decisions and took actions to gather information and collect evidence in both the Trump-Russia matter and the special counsel probe. Agent Strzok also admitted that before and during that same year...
A point of order, Mr. Chairman. We had a closed hearing on Peter Strzok. If you want to tolerate his testimony like this, release the transcript. Have an open hearing. Don't characterize and not let him testify. Don't take things out of context. Release his transcript.
That is not a valid point of order. The gentleman proceed.
So Agent Strzok also... Agent Strzok also...
Gentleman states point of order.
I assume it is a valid point of order to object to quoting or characterizing statements in a confidential setting.
Release their transcript, Mr. Chairman. Right. The American people deserve to hear Peter Strzok's testimony under oath. Do not hide his testimony.
Wait, let him rule on my point of order.
The testimony, Mr. Chairman, as you know from transcribed interviews can be used for hearing purposes.
Release the transcribed interview to the American people.
The transcript will be released to the American people at the appropriate time, but the gentleman can use it for the purpose of this question to the witness in the hearing.
We were under the impression, Mr. Chairman, that these transcripts were not to be quoted.
The chair has ruled.
Gentlemen, so Agent Strzok also admitted that before and during that same year, all right. Agent Strzok admitted that before and during that same year, he sent many, many text messages about Donald Trump. Text messages that we've already established and you've agreed.
It's going. It's a little recalcitrant.
The gentleman finished? So again, Agent Strzok sent many text messages about Donald Trump. We've established and you've agreed that those reflect a hatred and bias towards Donald Trump. Now, I reviewed with Agent Strzok, and he confirmed that he was, in fact, the person who sent the text messages that said, F Trump, Trump is an effing idiot, that talked about stopping Trump from becoming president, that talked about impeaching Trump as the president, that talked about protecting the country from Trump, and talked about an insurance policy against the risk of a Trump presidency, just to name a few. Those are the very same texts, by the way, that Inspector General Horowitz, as you know, characterized as deeply troubling and expressed his concern that Agent Strzok may have acted upon the bias expressed in those Trumps in prioritizing his work on the Russia collusion investigation on the Wiener laptop issue, a matter that he's now investigating. Now, when I asked Agent Strzok about his conversations with Special Counsel Mueller or anyone on his team about his removal, he described the details of a single conversation. He said it lasted about 10 or 15 minutes, but certainly less than 30 minutes. He said Special Counsel Mueller made it very clear that he was being removed from the case because of the text messages, but I was surprised that he said that neither Special Counsel Mueller or anyone on his team asked him about the text or his expressed hatred of Donald Trump. He said Special Counsel never asked him what he meant when he sent those texts. He said that Special Counsel Mueller never asked him if he acted upon the bias and the hatred reflected in those texts. I asked Agent Strzok at least a half a dozen times, did Special Counsel Mueller or anyone on his team ever ask you about these troubling text messages and whether any of your actions taken, whether any of your decisions made, and whether any of the evidence you collected may have been corrupted or tainted or in any way influenced by the hatred, bias, or prejudice expressed in these texts? He repeatedly and unequivocally said no. Yes, we know that Special Counsel Mueller removed him from the case, but what did Special Counsel Mueller do to determine whether or how the actions taken, the decisions made, and the evidence gathered by a Donald Trump hating lead investigator, how that may have prejudiced Donald Trump as a subject? Evidence, by the way, that Agent Strzok unequivocally stated in the presence of FBI counsel that became part of the Special Counsel Mueller's foundational evidence and that was used by the Special Counsel team. If Special Counsel Mueller was here, I know what I would ask him, but he's not, but his supervisor is. So, Mr. Deputy Attorney General, what, if anything, has Special Counsel Mueller done to determine whether the actions taken, the decisions made, and the evidence collected by Special Agent Peter Strzok was impacted by his very clear hatred and bias of President Trump?
Congressman, as I know you're aware, Director Mueller has vast experience both as a prosecutor and as a supervisor of the FBI. So I can assure you that he understands the importance of considering any credibility issues in determining whether or not to rely upon a person. With regard to the...
Well, so let me stop you. So what actions has he taken as his supervisor?
Well, we're not going to talk publicly about the substance of the investigation.
I don't want you to do that.
So
can you tell me whether you know he has taken steps to determine?
Yes. Director Mueller has taken appropriate steps. And keep in mind, Congressman...
Well, so let me stop you there. I'm thrilled to hear that he's taken steps. You and I are both former prosecutors. How does a prosecutor go about eliminating bias, prejudice, and expressed hatred from foundational evidence? Because you know, of course, that if your root evidence is fairly called into question, everything that comes from that evidence is fairly called into question, right?
Sir. Yes, I realize I'm just about out of time, but to give a somewhat comprehensive response, as you know, when we conduct an investigation, the purpose is to determine whether or not there's sufficient evidence to prove a case in court. And if you're going to court and you're taking a piece of evidence, you're relying upon a witness, you need to consider any issues that go to the credibility of the witness or the credibility of the evidence. And so you use the term foundational evidence. I'm not sure exactly what you have in mind, but if, for example, Director Mueller were to rely upon a document that Mr. Strzok produced or a statement that he took or were to call him as a witness, obviously you need to consider that evidence that would be evidence that would tend to impeach his credibility. And Director Mueller well knows that. And I just wanted to quickly respond if I could, and I recognize we're out of time, but Director Mueller and I learned about this issue at the same time. And we learned about it from the Inspector General, brought it to our attention soon after he discovered it. I believe it was last July. And so it was our understanding that the Inspector General was conducting an investigation of Mr. Strzok. So the fact that Director Mueller didn't spend a lot of time questioning him, I think that was probably appropriate because that was the Inspector General's job. But I would also point out that I don't think it took Director Mueller very long after seeing those text messages to decide what was the right thing to do.
Thank you. I yield back.
Chair recognizes the gentleman from New York, Mr. Nadler, for an opening.
Thank you.
For his questions.
Last month, I wrote to both of you regarding the apparent outing in the media of a confidential human source involved in the early stages of the Russia investigation. I understand that while I was on the floor just now, one of my Republican colleagues had the gall to quiz you about his identity again today. In my letter, I asked that you, quote, investigate this case for potential violations of the Intelligence Identities Protection Act, as well as other statutes and department guidelines designed to protect the lives of covert operatives and confidential human sources, close quote. Director Wray, last month you testified before the Senate that the day that we can't protect human sources is the day the American people start becoming less safe. Can you further and briefly explain what you mean by that statement?
Congressman Nadler, In investigation after investigation in the counterintelligence front, the counterterrorism front, organized crime front, human trafficking front, and virtually every area of enforcement that the FBI is responsible for, we rely heavily on human sources to come forward and share information with us, often at great peril to themselves and to their families. And that is one of the single most valuable and important tools that we have to keep the American people safe. And it's something that we've relied on for now coming up on almost 110 years of the FBI. And if we start losing that tool because people don't trust us to protect their identities appropriately, the American people will be less safe.
Oh, thank you. First of all, happy 110th birthday. It seems that Chairman Nunes has now asked the FBI for the identities of all, quote, undercover agents and or confidential human sources, close quote, who may have interacted with the Trump campaign. Have you received this request, Director?
I am aware that we received a letter very recently from Chairman Nunes. I haven't looked at it closely yet.
Would it be dangerous for this information to be made public? The identities of all undercover agents and or confidential human sources who may have interacted with the Trump campaign?
Well, as I said, we're going to do everything we can appropriately to protect sources and methods. We are also going to do everything we can to be responsive to legitimate congressional oversight. And my experience has been that when both sides, both the Congress and the executive branch, come into it with the recognition that both are important, Congress needs its questions answered, but sources need to be protected, and we're going to do our best to make sure we do both.
Would be dangerous. The public revelation of those names might be dangerous.
Public revelation of source identity or anything that could lead to source identity would be dangerous.
Thank you. Mr. Rosenstein, in a January 2000 letter to Representative John Linder, the Department outlined the rationale for its longstanding policy to decline to provide congressional committees with access to open law enforcement files. The letter acknowledges that Congress has a clear legitimate interest in determining how the Department enforces statutes, but also notes that disclosure of documents from our open files could also provide a roadmap of the Department's ongoing investigations that could fall into the hands of the targets of the investigation through inadvertence or a deliberate act on the part of someone having access to them, close quote. Mr. Deputy Attorney General, does the Linder letter still guide the Department's response to congressional requests for information?
Yes, Congressman. I've tried to explain this issue to some of your colleagues. Yesterday, I wrote a lengthy letter to Chairman Grassley with a copy to Chairman Goodlatte that goes into some detail about the background and explains why it is, sir, that this committee would not want us to turn over every document in FBI files. This committee would want us to exercise appropriate responsibility to make sure we're not damaging any case, risking the life or safety of any informant, or causing harm to national security.
Okay.
And that's what we're doing.
Thank you. Finally, Mr. Rosenstein, I'm sure you hear complaints that the special counsel's investigation is taking too long. I don't know what Mr. Mueller knows other than what he has put into his charging documents and plea agreements. Everything else we hear about the investigation has either been leaked or made up entirely by President Trump and his lawyers and then repeated by Republicans hoping to undermine the special counsel. I don't know what Mr. Mueller knows, and most of my colleagues are similarly situated. But you know the case better than anyone else. So I have three brief questions. Is the special counsel's investigation taking too long? Has he deliberately slowed his pace? And when his work is done, will the American people look back and view it as a waste of time?
Sir, I can assure you that Director Mueller is moving as expeditiously as possible, consistent with his responsibility to do it right.
He has not deliberately slowed his pace?
Of course not.
And when his work is done, the American people will look back and not view it as a waste of time?
People can draw their own conclusions, sir.
And finally, my last question before the bell rings. Is it atypical or typical for an investigation of this magnitude to take as long as this is done?
No, sir. I don't think it's atypical at all. I believe that it's being done as expeditiously as possible. That was one of my goals in appointing somebody I knew would be focused on the task, would not be distracted by other matters, and would get it done right and as quickly as possible.
So it's typical, not atypical?
Well, every investigation is unique, but I think for investigations of this type, I believe it's not atypical and it's certainly not unduly long, given the nature of the investigation.
Thank you very much. I yield back.
Chair recognizes the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman. Mr. Rosenstein, I had a telephone town hall meeting last night with people back home. That's where people get to ask us questions. We try to respond to them to the best of our ability, and quite a few people participated. And here's what one lady asked me. Congressman Shabbat, what's your reaction to the Inspector General's report? And how do you feel about the bias to exonerate Hillary Clinton by the DOJ? And where do you stand on holding Rosenstein in contempt for withholding documents? You're getting pretty famous. What I see out there and I hear out there among a significant portion of the American public, including that lady who asked me that question last night, is a great deal of skepticism, of mistrust of their own government, particularly mistrust of high-level people within the Justice Department. I really think that's a shame. But I guess it shouldn't be surprising, not when you consider what they've seen from their own government in recent years. Now, I happen to represent the city of Cincinnati and some other areas surrounding that area, and we have an IRS facility there. And in that facility, likely at the direction of higher-ups in this city, Washington, they were targeting conservative groups for special harassment and ignoring liberal groups. And the President of the United States, Barack Obama, who was supposed to ensure that investigations of such matters were handled fairly and without bias, instead went on TV and gave his opinion and probably gave a signal to all the investigators under him that there was not even a smidgen of corruption. That was a quote from the President at the time, not even a smidgen of corruption. And the person who headed up that improper targeting, Lois Lerner, not only took the fifth and refused to testify, but she was found in contempt by this body, by the United States House of Representatives, with no consequences. No wonder many Americans are skeptical. They've seen an investigation of one presidential candidate, Hillary Clinton, that was supposed to be unbiased, but the proverbial thumb was on the scale to her benefit. She sets up an illegal email server and swears she never sent classified emails, but she did, and gets a pass. FBI Director Comey, who's supposed to be unbiased, drafts a statement exonerating her before he's even interviewed her. Hillary's staff gets immunity deals that smell to high heavens. Hillary's operatives use hammers and bleach bit to destroy sought-after cell phones and emails, again, with no consequences, and on and on. But the other presidential candidate, the one who actually won but wasn't supposed to, well, he's treated very differently. A team of supposedly unbiased investigators turns out to be anything but. 9 out of the 16 have made political contributions, almost all to Democrats, including Hillary Clinton and Barack Obama. None gave to Trump. And 2 of them, as we've heard over and over again today, were communicating back and forth about how they were going to stop candidate Trump from being elected, and even had a so-called insurance policy, a pretty sinister sounding thing, to make damn sure he wasn't elected. So my question to you, Mr. Rosenstein, is this. Do you see why that lady last night might believe there's bias in the Justice Department and how these investigations, when you compare one to the other, have been carried out?
Yes, sir, and I share your concern. As you know, I wasn't the one running the investigation in 2017. I absolutely share your concern. I understand that. And I think one of the challenges that we face, and Director Wray and I are very familiar with this challenge, is that the culture of the Justice Department in which we operate, now there are exceptions obviously, but the culture in which we operate is one in which we make a conscious effort not to consider partisan issues. In fact, the way I've run my offices, I've been a manager in the Justice Department in a number of different capacities at this point for about 16 years or so. I've been very attuned to this issue.
Let me stop
and
there.
I make every effort, Congressman.
I'm running out of time. My time's very short at this point. I appreciate that you weren't there. You are now, so we appreciate your cooperation, appreciate your hard work. So let me just conclude with this. The American people, like that lady last night who asked that question on my telephone town hall meeting, and of course she felt that there was bias by the DOJ investigation, clearly by the way she asked it. I think the American people deserve a whole lot better than what they've been getting from their Justice Department of late. They have a right to unbiased, fair investigations. They have a right to expect equal treatment and equal justice, whether a person that they're investigating is a Democrat or a Republican, whether they're conservative or liberal, whether they were expected to win an election or not, whether their name happened to be Hillary Clinton or Donald Trump. And I'm afraid that's not what happened here. And I yield back.
Congressman, as I was saying, I do share your concern. One of the challenges that we face, sir, is that we operate in an environment where in our interactions in the office, we make every effort to avoid any references to politics, and where we focus on the facts and the law, and we consider all the evidence before we reach conclusions. American people are getting their information from other sources, and they don't always hear both sides. And I think it's important, sir, this gives me and Director Wray an opportunity to explain the way that we're running our organizations. There are going to be mistakes, but I think the assurance of the American people comes in our commitment to follow the rules. There were violations of the rules. I recognize that. We're making every effort to make sure that doesn't happen on our watch. With 115,000 employees, we're going to have issues as well, but I can assure you that we're going to deal with them appropriately. And with regard to my commitment, Congressman, the Attorney General has been very clear about his desire to ensure that the Department follows regular order, that we follow these traditional rules and practices. And if we adhere to these rules, there will sometimes be skeptical questions because we're not able to respond publicly to criticism. But at the end of the day, Congressman, I can assure you the cases that are brought on our watch are going to be in compliance with the rules. And so I hope that over time, seeing us follow the rules, the American people will regain whatever confidence they've lost. Because as Director Wray said, these folks we work with day in and day out, they are almost all there to do the right thing. And to the extent that they're not, we'll hold them accountable.
Thank you. I yield back.
Chair recognizes the gentleman from Illinois, Mr. Gutierrez, for 5 minutes.
Thank you very much, Mr. Chairman. Mr. Rosenstein, the President likes to use the term 100%. So I want to make sure that I'm 100% sure. The President of the United States did appoint you to your position. Is that 100%?
Yes, sir.
Mr. Wray, you're the new FBI director. I knew the ex-FBI director before he was fired by the President of the United States. Is it 100% that this President appointed you to the position that you currently hold as the FBI director?
Yes.
So 100%. So we don't have, there's no wiggle room here. It's 100% like the President says. So I would just want to ask you, they keep talking about the 13 angry Democrats that are running the investigation. Mr. Wray, are you one of those 13 angry Democrats that my Republican colleagues keep referring to?
Well, Congressman, of course, I'm not working on the special counsel investigation.
But you're the head of the FBI. Are you a Democrat? Did the President reach over to the Democratic Party as presidents have and pick you because he wanted to have Democrats in his administration?
Congressman, I'm trying to do this job apolitically, but I do not consider myself an angry Democrat. You can be quite confident.
Are you a Democrat? Are you a Democrat?
No, I am not.
You're not a Democrat. Thank you. Maybe I should have gone to that question. Mr. Rosenstein, are you a Democrat?
I'm not a Democrat, and I'm not angry.
And you're not angry. Well, I could understand if you were angry, however. I could understand that totally. And you have done a remarkable job of restraining yourself and containing any anger. So I want to just ask you, Mr. Rosenstein, what was the purpose of appointing Mueller as special counsel?
Congressman, as I said at the time, and I've repeated previously, the purpose of the appointment was to ensure that the investigation would be completed in a way in which the American people could have confidence.
Good. Now, I want to go to what I believe 3 basic questions are, and see if we can reach some agreement. Number 1, was our country attacked by a foreign government that wanted to influence the 2016 elections in order to undermine the United States? Was our country attacked? Now, was our country attacked, Mr. Rosenstein?
Congressman, we have the assessments of the intelligence community, and we also have an indictment that was returned that charged foreign nationals for interfering with an election.
Thank you. Mr. Wray, what's your opinion?
Same answer.
So, the head of the FBI and the Deputy Attorney General, relying on the intelligence community of the United States, including the FBI, have determined that our country was attacked in order to influence our election. Yet, that's not the purpose of this hearing. The purpose of this hearing is to undermine the FBI, to undermine Mr. Rosenstein and to undermine our system of justice. If that attack has already been established, why are we asking questions that undermine the very people that are at the head of this investigation? I'll tell you why. Because the majority doesn't want the end and a conclusion to this investigation. Number two, would part of the investigation be, Mr. Rosenstein, Mueller's investigation, has anyone taken steps, either during the campaign or since being sworn in, to lie, obfuscate, obstruct, misdirect, or undermine the investigation into the attack that you said occurred? Would that be part of Mr. Rosenstein, of Mueller's investigation?
I haven't commented, Congressman, on the subject matter of the investigation, but the special counsel does have authority to investigate any obstruction that occurred in the course of the investigation.
So on two basic questions, we agree. Mr. Wright, would you agree that that would be part of the, you're helping the investigation, your agents are helping, right?
We have agents working on special counsel
Thank you. So you're part of the investigation because your agents are working on it. Would you agree that part of the investigation is obstruction, obfuscation, or otherwise trying to derail the investigation that Mr. Rosenstein appointed Mr. Mueller to conduct?
Well, I'm not going to discuss the scope of Special Counsel Mueller's investigation, but I'll agree with the Deputy Attorney General's comments already.
Well, he said that it would be part of it. So in agreeing with him, we've established two things. Our government and the American people were attacked, and our democracy was attempted to undermine, and that part of that investigation should be. So I just want to ask the chairman, if he would, I'd like to enter this, because Mr. Rosenstein, it doesn't matter. They want you. They want to impeach you, they want to indict you, they want to get rid of you. Because in getting rid of you, they want to stop the two fundamental questions that we already agreed to. And that is, they want to undermine this investigation. So Mr. Rosenstein, good luck. We're in the minority.
The chair recognizes himself for purpose of asking questions. Deputy Attorney General Rosenstein, we recently learned that your department is interpreting the Judiciary Committee's subpoena in a manner that restricts a particular set of documents from being produced to Congress. Specifically, we have been told that we have not received documents that were given to the Inspector General pertaining to communications between DOJ prosecutors, between officials of the department, including former Attorney General Lynch and Deputy Attorney General Yates, and in any communication between DOJ officials and the White House. You are well aware that we requested multiple times prior to our subpoena all documents and communications given to the Inspector General with minimal exclusions. Why have you not produced these documents and communications pursuant to the subpoena?
Congressman, I don't necessarily know that I'm well aware, but we do have, as you know, a staff that's working diligently with you and with your staff. Now, with regard to the subpoena, sir, I've heard these suggestions that the subpoena may not be valid. It doesn't matter to me. We're trying to accommodate Congress by providing you the information that you need to complete your responsibilities. I welcome the opportunity. I wish I had more of an opportunity to tell our side before anybody voted on this issue this morning. But it's important for you to understand, Congressman, that we're going to do everything we can to accommodate your requests. And if somebody misread or if you intended to obtain information that wasn't provided, I'm going to make sure that happens. I spoke briefly to Mr. Lausch at the lunch break. I was not previously aware of this issue, but he assured me that he's going to work with your staff to ensure you get what you need. I understand that there's some correspondence with department officials, but if there's more that's relevant to you, we'll make sure we identify it and get you what you need.
You plan to do so immediately?
Pardon me?
Immediately.
Yes, sir. Well, keep in mind, immediately when you're talking about 1.2 million documents, Mr. Lausch, if he were testifying, he'd be much more effective than I because he's handled these productions in the private sector. It's as quickly as we can. As Director Wray said, people are working day and night.
I've got limited time and a few more questions. So let me ask you, are there any documents pertaining to the Clinton investigation that were not provided to the Inspector General?
I do not know, sir. I wasn't around at the time that the Inspector General collected those documents.
No one, to our knowledge, has been indicted or held criminally liable for the spillage of over 100 classified emails over unsecured and unclassified servers and accounts. Those of us who hold security clearances wonder whether the executive branch still takes seriously oversight of handling of classified information. So, does DOJ ever plan on holding anyone accountable for the significant spillage of classified information during the Clinton reign as Secretary of State?
Sir, in the event that the evidence is sufficient to prove beyond a reasonable doubt that a crime was committed and it meets our principles of federal prosecution, yes, we would prosecute it.
How much of your job involves access to classified information?
Sir, it varies really from day to day or week to week, but certainly a significant component.
But you would, how would you characterize setting up a private server to conduct your business that would inevitably lead to classified information passing across that server?
Sir, I don't want to comment on the case. I can tell you from my personal perspective, having been a government employee for 30 years, we do not expect government employees to be conducting government business on their personal accounts. Now, occasionally there may be exceptions, but as a general matter, the purpose of the government email system is to capture all the official correspondence.
Is that gross negligence or extreme carelessness?
I don't want to put a legal standard on it, sir. It just isn't something we...
There is a legal standard. It's in the statute.
Right. Your question is, on anybody's conduct, you need to evaluate the facts and circumstances of the case. But I trust that our employees know that official business should be done on Department of Justice servers.
What would happen to me as Judiciary Committee Chairman if I set up a private server and conducted all my government business and classified information passed through that server?
Well, as you know, Congress has speech and debate privilege, so they're not governed by exactly the same rules, sir, but I would hope that you would not do that.
Mr. Wray, we have repeatedly asked FBI personnel whether the fact that an agent has an extramarital affair is a problem. I'm not asking because I want to be the morality police. I'm asking because it seems clear that an affair that is unknown to a spouse could be a significant vulnerability for an FBI agent, especially a counterintelligence agent. Do you agree with that sentiment?
Well, Mr. Chairman, we have a specific offense code, and I don't want to comment on any of the ongoing personnel matters that are going through the disciplinary process right now, which I think answering your question at this particular time might cause me to do.
And finally, Mr. Rosenstein, in light of the decision by Inspector General Horowitz to look at the potential abuse of the FISA process, are you currently signing FISA applications?
The normal process is that there are 3 people authorized to sign them, and the low man on the totem pole gets the responsibility. So generally speaking, to be the Assistant Attorney General for the National Security Division, if he were absent or unavailable, or occasionally if there was a matter in which he might have a conflict, then it would come to me. But I want to assure you, Mr. Chairman, there's no reason that I should refrain from my responsibility to sign FISA applications when they meet the standards required by the statute. In fact, it would be a dereliction of duty for me to fail to approve a FISA that was justified by the facts and the law.
Thank you. Chair recognizes the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, earlier in his questioning, in his statement, Mr. Gowdy had some interesting things to say. He said that he acknowledged that Russia attacked this country and that they should be the target. Then he went on to say, but Russia isn't being hurt by this investigation. We are. The country is being hurt by this investigation into Russia's meddling in our election. I would ask General Rosenstein, Director Wray, what is the purpose of this investigation?
Congressman, I think that there are actually 2 different issues. The first is this investigation, which is an historical investigation of interference with the 2016 election. The second question, which I think is of tremendous importance, is what's happening now and what's going to happen in the future. And I think it's important for the American people to understand that this is not a one-shot deal. There are foreign countries that on a regular basis are attempting to infiltrate American computer systems and interfere in our democracy. And the FBI has a task force that is focused on this problem. It's working with officials in the Department of Justice, and we're going to continue to do everything that we can to protect the American people against this sort of abuse.
Director Wray, when Mr. Gowdy says, and again, I quote my friend, whatever you've got, finish it the hell up. Can you tell me the way the FBI conducts investigations, and does it operate on the timeline that permits it to gather the evidence, all of it in full, or does it operate on the timeline established by members of the United States House?
Congressman, we are not going to do our investigation subject to any political influence by either side. We are going to do our investigations as expeditiously but responsibly as we possibly can. As I've said repeatedly, we're going to play it straight and by the book, and that would extend to every investigation that we have responsibility for.
General Rosenstein, you submitted a letter to Senator Grassley, the chairman of the Judiciary Committee in the Senate, also a letter to Speaker Ryan about the resolution. You actually you take great length to explain the way that you've been complying with congressional oversight, working diligently and in good faith to provide an unprecedented level of congressional access to information that members of Congress believe may be relevant. Since there have been so many accusations about the way you've conducted this, I thought it would be helpful for you to spend just a couple of minutes explaining how it is that you have been cooperative, the volume of the documents you've been provided, and anything else that you think would be relevant in our understanding, and that would have been relevant had members had the chance to hear it before being rushed to the floor to vote on that resolution.
Congressman, I don't want to comment on the motivation of anybody who's proposing resolutions. That's within the domain of Congress to make those determinations. If anybody's voting on me, though, you would think that they would want to know the truth before they voted. And if you wanted to know about all the things we're doing to comply with congressional subpoenas and document requests and all the many inquiries that we get, you wouldn't have to talk to just me. You'd have to talk to the dozens of folks who are working diligently every day to try to comply with these requests. So I'm happy to take whatever blame you want to assess. That's one of my jobs. But if you want a true understanding of what we're doing, it would take a very long time. And as Director Wray adverted to, when you say 880,000 documents, it's a lot, but it still sounds like just 880,000 documents. But you're actually talking about collecting documents from throughout the organization and then reviewing them to make sure there's no grand jury information, to make sure you're not exposing any informants, to make sure you're not including any personal information that the Congress probably doesn't want. And so it's a complicated process, and it's difficult to explain even in a minute or two. But as I said, if you actually had a full and fair review of what we're doing, I'm confident that you would recognize we're doing everything we can to comply. And whether people vote or don't vote, as I said, we're going to do everything we can because we believe, and frankly, the President has made quite clear that he wants us to be as transparent as possible, consistent with the restrictions that we have, and we're complying with that advice.
Mr. Rosenstein, Director Wray, I very much appreciate your coming. I very much appreciate your agreeing to testify under oath. And I would finally just take exception, vehemently so, with the assertion made by my friend Mr. Jordan earlier, who said, and I quote him, "Well now, who are we supposed to believe? The staff members who we've worked with, who have never misled us, or you guys who we've caught hiding information from us?" That's a question that he asked you, Mr. Rosenstein, as you were answering questions under oath. The only conclusion from a statement like that, from a question like that, is the suggestion that you've appeared before us and under oath are lying to the members of this committee. It is offensive. It was inappropriate for my colleague to do that. I regret that he had, and I yield back the balance of my time.
The Deputy Attorney General is allowed to respond if he chooses to do so.
No need, Mr. Goodlatte. Thank you.
The chair recognizes the gentleman from California, Mr. Issa, for 5 minutes.
Mr. Rosenstein, I want to start by characterizing my questions as all related to what I perceive as a double standard. The standard that the American people live under versus the standard that you all live under. And I'm just going to give you one quick example. I think they brought you down a copy of it. 2 U.S.C. 194 says, it shall be the duty of said President or Senate or Speaker of the House in the case where they certify, I'll get to a bottom line even shorter, when we find somebody in contempt and refer it, the U.S. Attorney for the District of Columbia, whose duty it shall be to bring the matter to a grand jury for its action. Now, under both President Bush and under President Obama, you two and your predecessors have decided that you're going to consider shall as a, if I feel like it, if I think the case is worthy. I will consider it de novo and in both cases not do it. So let me ask a simple question. Under 2 U.S.C. 194, if either of you are held in contempt, will you allow the U.S. Attorney to bring that case before a grand jury pursuant to the law, or will you, like your predecessors, object?
Congressman, I'm glad to say that I'm actually not familiar with that issue. I haven't dealt with it before. I do have a copy.
Well, you were serving at the Department of Justice under both of these cases, the Harriet Myers case and then the Fast and Furious, where the Attorney General himself were held in contempt, and they obstructed and did not allow the case to go to the U.S. Attorney. You oversee U.S. attorneys, including the one for the District of Columbia at this point. U.S. Attorney for the District of Columbia did not make that decision in a vacuum. That decision was made at the highest level of the Department of Justice simply to hold out. Now, ultimately, an Obama appointee gave us much of the information that we wanted. It was far more than the Attorney General, who lied to us about how much was there, said there was, and ultimately it uncovered obstruction by the Attorney General. So the question is, would you allow the statute to go forward that says shall present to a grand jury, or do you believe that you have the ability to be above the law, something the American people do not?
No, sir, I do not have the ability.
Good. Since you do not believe that, I will take that as if you're held in contempt, it will go forward. You said no, and yes or no was fine, that you don't believe you're above the law.
Correct.
The former director of the FBI came before, he was exactly where Mr. Ray is sitting, he was that far away, and he told us that nowhere in the FBI did you have the capability of cracking open an iPhone, and as a result, you needed to go to court, you needed to order and get an order to force Apple to create a back door so that you could remotely get into it. Now, that turned out to be untrue. Mr. Ray, do you have the ability, do you have a great organization, or do you have the inept group that was unable to do it until shortly after his false statement here, when it was uncovered that for about $250 it could be done and has been done?
Well, Congressman, certainly I think we have the premier law enforcement and national security organization in the world.
The real question is, when he came here and said he had exhausted all capabilities, he was not telling the truth, because shortly afterwards, very simple assets allowed that, and of course, Apple never had to produce it. So the question is, now let me go on because I have limited time. Recently, Mr. Comey was given an advance copy of the Inspector General's report, in return for which he signed a non-disclosure agreement. He violated that non-disclosure agreement in that he contacted a news source more than 4 hours beforehand, because it was published 4 hours before it was released, probably 24 to 48 hours in advance. Will you agree to look into whether or not he violated that NDA, since there is no authority, obviously, by the Inspector General? Will you agree to investigate former Director Comey, not allow a double standard for his violation of that non-disclosure agreement?
Well, Congressman, I'm certainly not going to be commenting here on whether or not we're going to open or not an investigation into someone. I will say that I haven't.
So you're just not going to say whether he's above the law or not for what he did?
I'm sorry?
You're not going to say whether he's above the law or not?
I do not think there's anyone on this planet who's above the law.
Well, we'll see whether or not you actually open an investigation. That will tell me that. Now, yesterday, Mr. Strzok managed to have your attorney obstruct us from getting the answers we wanted by claiming that, in fact, he wasn't going to answer questions, even if they were tangentially related to an ongoing investigation. Do you stand by that today, that, in fact, behind closed doors in a classified setting, we are not entitled to those questions answered?
The time of the gentleman has expired, but the witness may answer.
I would like to answer that, yes. So, Congressman, I was not present, as you know, for the interview, and I understand you all talked to him for 11 or 12 hours, and I don't know the specifics of what questions were asked, which questions were objected to, and what the context is. And in my experience as a prosecutor and as a lawyer on the other side of it, those kind of details matter. So I really can't speak to whether or not any particular objection made sense, and I would need to know a lot more about that. I will say that it is a long-standing principle recognized by the Inspector General in this report that we don't discuss ongoing criminal investigations, not just publicly, but with Congress.
Mr. Chairman, for the record, the 800,000 or so records that earlier, the Deputy Attorney General was talking about how difficult and how long it took to produce them. Is it my understanding that they're being looked at in camera, and as such, if there were any information that of the type that they said they want to protect, those could be objected to before they're released? Isn't that true?
That's correct.
So the fact is, all of the objections that we've heard about the delay really don't apply when it's in camera, do they?
I can't answer that question, but
perhaps one of the individuals
director
can.
or the Attorney General would like to respond. They are welcome to.
Well, I'm happy to respond in part, which is that even information that's provided in camera has to be reviewed first, for example, for grand jury secrecy, which we are prohibited from disclosing. So there are some things that we have to review for, even to put it in the in-camera room. Legally, we're required to. There are many more things that, based on discussion with the chairman and his staff, that would then be relevant to any subsequent production. So you're partially right, but there are some things, some significant things that have to get reviewed for, even before it goes in the reading room, legally.
Mr. Chairman, may I respond?
Yes.
The issue of contempt, as I said, I'm not familiar with that particular statute or what the Department's policy has been, but I would like, I have the advantage of having been a lawyer for 30 years and a prosecutor for almost 30 years. Just to explain, I made an effort in this letter to explain. I recognize that not every member of Congress is a lawyer, let alone a prosecutor, but I set forth in my letter an explanation of the history of the accommodation process between the executive and legislative branches. I think it's important to understand, Mr. Chairman, that the fact that the Department receives a subpoena and is unable to comply immediately because of volume or the need to make redactions, that doesn't mean that we're in contempt. And there sometimes may be legitimate differences of opinion as to whether or not certain information is subject to being produced. It doesn't mean you're in contempt. There are mechanisms to resolve this without threatening to hold people in contempt, which is in fact a crime. So my recommendation, Mr. Chairman, is if there are differences of opinion, read the letter, understand how this has been done historically. We'll resolve it. If it needs to be resolved by a judge, you can seek enforcement of your subpoena civilly in court. But I can assure you, Mr. Chairman, I'm working with a really superb team, some of the best lawyers in the country, Republicans, Democrats, career, political appointees. We are not in contempt of this Congress, and we are not going to be in contempt of this Congress. Thank you.
Thank you. Chair recognizes the gentlewoman from California, Ms. Bass, for 5 minutes. Oh, okay. So if you're, the ranking member advises me that Mr. Cicilline has a pressing need to go first. So he's recognized.
Thank you, Mr.
5
Chairman.
minutes.
I thank the gentlelady from California. Thank you to our witnesses for being here. And we're here today because the FBI violated a longstanding policy of not commenting on anything related to an ongoing criminal or counterintelligence investigation in the summer and fall of 2016. This violation resulted in a 1.5-year IG investigation, a 500-page exhaustive IG report, and it's the genesis of 3 concurrent investigations in the House alone. Last week, I attended, along with my colleagues, a 6-hour hearing with the IG on the FBI's violation of this policy. Yesterday, our Republican colleagues spent 11 hours trying to get the FBI to violate this same policy. And today, the Deputy Attorney General and the FBI Director have been brought before us in an attempt by our friends on the other side of the aisle to force the FBI in this open forum to violate this policy all over again. And all of this is an attempt to discredit the Department of Justice, to undermine the special counsel, and to protect President Trump. And I'll say at the outset, it is my hope and prayer, and I know the prayer of the American people, that for the sake of our country, that you both remain strong and faithful to the oath that you've taken, no matter how much bullying you endure in an effort to persuade you to violate this sacred responsibility, whether it be by way of letter, by way of contempt threats, by way of resolutions, or public hearings such as this. I was particularly disturbed to hear the chairman of the committee say the FBI and the DOJ are not in the Constitution, but the President and Congress are, and you must yield to us. Well, I remind the chairman respectfully, and I remind both of you gentlemen, you must not yield to us to the extent that doing so would require you to violate your oath to defend the Constitution and laws of the United States. And I hope that is the sentiment of everyone on this committee. Of course, we're having an emergency hearing about the Clinton emails. We're not having an emergency hearing on the corruption in this administration, the conflicts of interest and violations of the Emoluments Clause, the election security, which is so essential for our upcoming election, the family separation policy, which is ripping children from their parents, the failure to pass the DREAM Act, or address the scourge of gun violence in America, but we're having another hearing about the Clinton email server. And you know, I spent many years as a criminal defense lawyer. It would have been a really clever and very useful thing if I had the ability to demand information about an ongoing investigation during the course of that investigation. I never thought to do that because, of course, it's so obvious you are not entitled to that. And so this notion of making these demands in the hopes that you will continue to honor your oath and deny them, and they will use that as a pretext, as Mr. Gutierrez said, to take some action against you is something we should all guard against very closely. There remain 18 outstanding indictments, 5 guilty pleas from the president's deputy campaign manager and the president's former top national security advisor, among others. You have already said our country was attacked in order to influence the outcome of our election. My first question is, are foreign adversaries, including Russia, continuing to attempt to interfere with our next election?
Congressman, it is, I think, the consensus of the intelligence community that Russia, among other foreign powers, will continue to look for ways to influence our populace, whether or not they would try to interfere with the election in the sense that a lot of lay people think of it is a more of an open question. But certainly there is plenty of information to show that they continue to look for ways to try to divide us and sow discord, to undermine the faith of the American people in the democracy that we hold so dear.
And do you recall, Director or Deputy Attorney General, in all of the subpoenas and letters and demands for information, have our colleagues on the other side of the aisle written to you and asked you to come and provide information about the efforts that are being made to protect the 2018 election from any foreign interference?
Well, the FBI, I know, has provided numerous briefings on our efforts. As the Deputy Attorney General mentioned, I created a foreign influence task force dedicated to this topic. And while I can't speak specifically to, just because I don't remember exactly which committee they've done what with, I know we've provided a lot of briefings. We also, I personally addressed the full House of Representatives along with the Secretary of Homeland Security and the Director of National Intelligence on this subject.
And the IG report that was prepared, what was the subject of that report?
Well, I think the report largely speaks for itself, but the focus is on the handling of the Clinton email investigation.
And did that report address the independent counsel's investigation relating to Russian interference and coordination with the Trump campaign?
That's not my read of the report.
Okay. It's not my read either. And would it be correct that the president made a statement after receiving the IG report, and he said, and I quote, "This report totally exonerates me. There's no collusion. There was no obstruction," referring to obstruction of justice. Is that an accurate statement of the conclusions of that 500-page report, Director Wray?
The time of the gentleman has expired. The director can answer the question.
Yeah, Congressman, I'll let the report speak for itself.
Thank you. I yield back, Mr. Chair.
Chair recognizes the gentleman from Iowa, Mr. King, for 5 minutes.
Thank you, Mr. Chairman. To direct my first question to Mr. Rosenstein. Mr. Rosenstein, I know that you're a constitutionalist, and I think about the framework we're dealing with here in this Article 1 asking questions of Article 2. And I would ask is, in our role of oversight here, in our Article 1 role of oversight, is there any information that's housed within the executive branch, anywhere in the executive branch, that would be permanently and forever unavailable to the oversight of the United States Congress?
You know, I don't know the answer to that, Congressman, with regard to the information in the Justice Department. There are certain categories of information, as Director Wray said, that we typically wouldn't release. And my experience is typically the Congress doesn't want to know, for example, the identities of confidential sources. I think what's significant you need to understand is Director Wray and I don't know the names of the confidential sources. To the extent we ever hear them, they're masked. And so there is information that I think it would be inappropriate.
If I could just zero in on that just a little bit, because what I'm trying to get at here is that the public is never going to have confidence in this broader issue that we've been talking about for so long until as much information as possible can have sunlight on it. And Congress is not going to have confidence until we actually get information that we don't have to pull and try to fill in the blanks and then fill in the blanks of redactions, et cetera. And so I would submit that there's no information that's housed within the executive branch in whatever form, even if it's just institutional knowledge, that would forever be foreclosed from access to the United States Congress.
Yes, sir. I agree. Forever is a long time. But I certainly am sympathetic, and I understand your concern. There are certain.
So do you generally agree with me on that statement, though?
There are certain types of information, Congressman, that we've developed protocols with the intelligence committees where the intelligence agencies will actually provide briefings, at least at a high level, for information that's not further distributed. I know this is a challenging issue.
And I'm aware of that, and I'm not really going to take you down into specifics. I just want to get to this point that,
yes, sir.
And I'll assert this, and you can disagree with me if you like, or under the right format, whether it's in a SCIF, whether it's the people that are appropriate members of the committees of jurisdiction, Congress must eventually have access to all information that's housed within the executive branch of government, or that empowers the executive branch then to be beyond oversight. Would you agree with that?
There is an executive privilege, Congressman, and as you said, we don't want to have a constitutional debate.
Okay, let me turn that executive privilege back.
Right.
Again, what if the President of the United States just simply issued an order that all information relevant here that Congress is asking for is now declassified and directed you to release that to the United States Congress, in whether it be Select Committee on Intel here or oversight? Would you then abide by such an order?
And what I regret that you're not seeing going on behind the scenes is that Director Ray and I have been in regular contact with Director Coates and with the CIA regarding some of these requests, and our goal is to provide as much information as we can to the oversight committees.
But I'm not really hearing the answer to my question, yes, Mr. Rosenstein, which is if the President declassified and gave a direct order to simply come clean with all things of interest to Congress's oversight on these topics, would you abide by such an order?
Yes, but we'd have to talk about, when you say all information, I think Director Ray and Director Coates would presumably consult with the President.
I'll yield to the caveats. I just wanted to get to the point.
Yes.
Then there is a way, but that may be the only way that Congress is going to get this information necessary to put this whole jigsaw puzzle together and first have the confidence that we actually know what all went on. But just to move on, you gave the directive to Robert Mueller. And can you paraphrase to us the directive he has for that mission?
I don't want to paraphrase it, sir. I actually have in front of me a copy of the order, which assigns him to conduct a full and thorough investigation of the Russian government's efforts to interfere in the 2016 presidential election.
That's directly from the order that you've just
yes,
read?
Sir.
Thank you. Now that is available to the public, and I thank you for that. How many FISA judges are there?
Pardon me?
How many FISA judges are there?
I do not know the answer to that, sir.
And do you know how many FISA judges might have signed off on warrants relevant to this investigation? How many different judges?
You know, my understanding, there was information that was declassified, and I believe that the information declassified indicated one application renewed 3 times, so a total of 4. And I believe there were 4 different judges, but I don't know that for a fact.
Okay, but would their names be public?
The names of the judges?
Yes.
I don't know the answer to the
Okay,
the identities of
I've
the
got
judges
one
in
more
the FISA
question I want to
court.
ask before I run out of time, and that is, who was in the room with Hillary Clinton on July 2nd, 2016?
Lord.
We now know Peter Strzok was one of them. Who else was in that room?
I only know from whatever's in the report. I have no personal knowledge.
And do you have a way of finding that information out?
Well, that's the point that I've actually tried to make to several of your colleagues, is for something that happened before I got there and I didn't have personal involvement, I need to rely on other people to tell me the information, so I wouldn't know any more than what's in the report.
We must know that if we're going to get to the bottom of this.
Has expired.
I thank the gentleman.
Mr. Chairman, may
back.
I just respond briefly? And I recognize, Mr. King, that your time is limited.
Gentleman's recognized.
But what I want to assure you is we do think it's important for the American people to know of any wrongdoing that occurred. It's difficult for us to articulate that publicly. We rarely have time to respond publicly, but we are actually working very cooperatively with Chairman Nunes, and I respect what he's trying to do, and I think he understands that I'm trying to do the right thing. And so Director Ray and I actually have worked with him and provided classified briefings, and we're making an effort to get him all the information that we can. And I believe he knows as much as I know about these questions that he's trying to answer. And if there's anything else that he believes we don't know, he believes should be known by him, we're going to look for it. So Director Ray and I are not in any way trying to conceal any kind of wrongdoing from you or for the American people.
Now the gentlewoman from California, Ms. Bass, is recognized for 5 minutes.
Thank you, Mr. Chair. Let me begin by thanking both of you for your service to this country. We often have this phrase here in Congress that we associate ourselves with the comments and questions of colleagues, but I'd like to take a moment actually to disassociate myself with the manner in which I believe you two have been treated. And I believe that your service has not been respected. Now, having said that, you know, I've talked to both of you before about a subject matter that I'm critical of the department. But I'm critical of the department in the context of respecting your service and the service of your officers. So if you do remember me, we've had a couple of conversations about black identity extremists and about that report. And I've asked both of you at different times if you would look into the matter further. And I didn't actually hear back. And so I want to ask you questions that I've asked before. And we also had a meeting, it was a classified meeting with your departments. And I'm still in search of answers. And the answers I'm in search of is that if you have identified who drafted the report, and way more important than the individual, the department, and what was the basis for the report. And I'd like to ask both of you to respond to that.
You're talking specifically about the report regarding black identity extremism?
Black identity extremists likely motivated to target law enforcement officers is the long-winded name of that report.
Right, and so as to who drafted it, I don't have that information with me, certainly. I thought that the meeting that I had with you all and your colleagues, I think it was about 2 hours, I thought was very constructive. I appreciate hearing your concerns. I hope you understood at least how we went about what we did. It all happened before I arrived.
Yes.
That conversation has, I can tell you, prompted us to go back and take a very hard look at how we are bucketing the different categories of domestic terrorism. And I think it's been a useful learning experience for us, and I expect we will see some changes in how we do things going forward.
Oh, I appreciate that. Thank you very much. Deputy Rosenstein, thank you.
I believe you asked me questions about this in December when I was here, and I have no further knowledge of it beyond what Director Wray has, but I do want to assure you that based upon what I've seen of the FBI during my tenure there, when they use the term extremist, the FBI is focused on violence and violations of the law. They're not focused on people who are exercising their First Amendment rights.
So, you know what? When we did meet, I also asked both of you if you were aware of any cases. And that point, you said that you weren't. You didn't know of any investigations. But since then, you might be familiar with a case in Dallas where there was a young man who, you know, put some, in my opinion, crazy stuff on his Facebook page, but had no history of violence and wound up being incarcerated for several months. And the Black Identity Extremist document was the basis in which he was arrested. Are either of you familiar with that case?
I'm not.
No? How about you?
I'm not familiar with it, and the FBI's report would not be the basis for prosecuting or arresting.
Not prosecuting. It was the basis from which they, they labeled him that. And,
I'm not familiar with it.
Okay, so I would ask again, follow-up, I would appreciate it, because my concern that I raised to you then, and I still have that concern, is that until this report is retracted and clarification is made to thousands of police agencies around the country, that report can be used, especially if you have, when my concern is young African-American activists who might protest police violence, you know, whether it's a police shooting like the one that just happened in Pittsburgh, the guy running and was shot in his back, or in Sacramento, because these shootings continue to occur and they continue to be videotaped.
Well, as I said, we're continuing to look at the information we used for that report and the manner in which we described it. As I also, I think, said to you back when we spoke last, we have very strict guidelines about, not just in this area, but in any domestic extremism situation. We only investigate when we have those three things. Remember,
right.
Credible evidence of a violation of federal criminal law, number one. Number two, credible evidence of violence or a threat of violence. And then third, motivated by some extreme ideology. And if we don't have those things,
right.
Our folks are not allowed to open up an investigation.
So I would, in wrapping up, would ask if you would follow up. I'm encouraged to hear that it's caused, maybe some reconsideration. What worries me, though, is that if that reconsideration takes place within the department is great. But those 2,000 law enforcement agencies, if there is not correction, clarification, I still worry that it could be used, and so perhaps we could follow up with that.
Time of the gentlewoman has expired. Chair recognizes the gentleman from Texas, Mr. Gomert, for 5 minutes.
Thank you, Mr. Chairman. Deputy Attorney General, a common theme, it seems, to many of your responses has been basically, gee, I wasn't here then, that wasn't me, I didn't personally do that, I didn't redact Judge Contreras' name from the documents so Congress couldn't see that he was friends with Peter Strzok, that was someone else. But you have added quite pointedly to Mr. Jordan that I am the Deputy Attorney General, and you certainly are. But the actions of your subordinates, which are all employees of the Department of Justice, aren't you vouching for those? Don't those people respond to you?
Those people all ultimately report to me, yes, sir.
And that would include when Bruce Orr's office was directly next to yours, I believe. Isn't that correct? And he worked for you?
He worked in the Deputy Attorney General's office. I think it was a couple of doors down, but yes.
Okay, a couple of doors down. Well, we're aware of some of the events that occurred before your confirmation as the Deputy Attorney General. However, some of your team members certainly were involved. So I want to ask, was Tashina Gahar, your deputy, or Tricia Anderson involved in any stage of drafting, editing, or approving the 4 FISA applications to spy on Carter Page?
I wasn't sure if you were directing that question to me, but Congressman, sitting here right now, I don't know exactly who was involved in drafting what FISA application.
So just to be clear, apparently, Director Wray, you have to answer for the Deputy Attorney General about FISA applications he signed?
No, you were asking about...
Yeah, the 4 applications to spy on Carter Page.
Yes.
And I think you've been a bit vague on whether you even signed
No,
the
sir.
FISA.
Let me try to clarify for you, if I may.
Well, did you sign the 4th FISA application?
I approved the filing of a based
Okay,
on what's
now you say you
public
approved that application. Now, that's going before a FISA.
That's my job, sir.
That's your job, okay. You approved it. Well, when you approve a FISA application, in your mind, does that mean you should read it and understand what's part of it?
You should certainly understand what's part of it, sir.
But that you're parsing words, so that doesn't mean you need to read it, in your opinion. Is that correct?
It depends on the circumstances, sir, and...
well, telling you, being a former felony state judge,
yes.
If I had somebody like you come before me and now it was revealed later that the guy that signed and approved an application for a warrant had not even read the application that would allow spying on somebody, I would look at everything he signed from then on with a jaundiced eye. And I'm telling you, I was a little concerned about
to explain, sir?
Well, you have. You've said
no, I have not.
Approve it. Well,
I did approve it.
I didn't ask that question because you said you approved it, but you took out the words that you read it. And so it is my time.
Texas will suspend. I just want to make it clear to Deputy Attorney General, you will be afforded a full opportunity to respond once his time has expired. If he wants to yield to you during that
my time continued to run while the chairman took up some of my time. So
you'll have that too.
And actually, I was being interrupted. I did not have a question. I was taking the words that the Deputy Attorney General himself said. So, well, let me ask you about this. You said earlier Bruce Orr was not working on the Russia investigation. Let me ask you.
To my knowledge.
To your knowledge. Did you not know that Bruce Orr was meeting with Christopher Steele, getting the information about the dossier and supplying that information to the FBI at the same time his wife Nellie was working for Fusion GPS that was helping Hillary Clinton? Did you not know he was doing that for the FBI?
Correct.
You did not know that?
Correct.
Okay, so he officed a couple of doors down, but you had no idea that he was actually the go-between to get that information. So when did you find out about that?
So as I said, sir, the Inspector General is reviewing these FISAs, and I hope I have an opportunity to explain.
Well, let me just say, you look at the deputy, look at the summary. Mr. Horowitz said, we did not have confidence that Strzok's decision to prioritize Russia investigation over following up on the mid-year related investigations discovered on the Wiener laptop was free from bias. Pretty clear to most of us, his bias did affect that decision, and the
time of the gentleman has expired. The Deputy Attorney General may respond.
Thank you, Mr. Chairman. I apologize. I thought you were asking me questions, sir. I completely understand your concern. And this FISA process is being reviewed by the Inspector General. If he finds some problem with it, I'll respect that. Now, we don't talk about FISAs. It's illegal for us to talk about FISAs. In this particular example, as a result of the Intelligence Committee, certain information was declassified, and so I'm comfortable talking about that. You have to understand in context, sir, that the department had made the decision to disclose the existence of a FISA to the House and Senate before I got there. Now, what I signed was what's called a renewal application. Already been approved 3 different times by a federal judge. It was signed under oath by an FBI agent who attested that it was true and correct. Now, if he was wrong, we'll hold him accountable. But let's allow the process to conclude before we jump to conclusions about that, because I assure you, sir, I'll be just as offended as you if I find there was some incorrect information in that application.
Well, Mr. Chairman, since we've learned that he relies heavily on people that were part of his team to do these applications, I don't think we can get to the truth until we question Tashina Gahar and Tricia Anderson, and that would also include why she slow walks the notices of NSC meetings to the Attorney General when she's working for the DAG just to make him look bad. So we need to get those 2 people in here and question them.
Mr. Chairman, if I could respond, if there's any evidence of wrongdoing, sir, by anyone on my staff or anyone in the department, I would expect you to give them fair process, bring the information to my attention or the Inspector General's attention. Let's hear both sides, and then let's reach the conclusion. I think what's important to understand, and I understand the FISA process is very obscure to most people, but these are essentially search warrant affidavits. A federal agent has to swear under oath that everything in that application is true. And then there are review processes within the FBI and within the department. And ultimately, the decision is made by a federal judge. There can be mistakes, and we'll find out if there are any mistakes in this one. But it's not a matter of just slapping a document and signing it. It's a very thorough process. And in that particular case, 4 different federal judges found probable cause. The Inspector General will review it, and I'll await those conclusions, sir. But I just would encourage you not to jump to any conclusions that I or anybody else did anything wrong until we have all the information.
Mr. Chairman. A person, gentleman from New York, seek recognition.
Mr. Chairman, earlier I referenced a January 27, 2000 letter to John Linder, who was then the chairman of the Rules Committee, of the Subcommittee on Rules and Organization of the House of the Committee on Rules, from the then Deputy Assistant Attorney General Robert Rabin. I'd like unanimous consent to insert this into the record now.
Without objection, it will be made a part of the record.
I thank you, sir.
And the chair recognizes the gentleman from California, Mr. Swalwell, for 5 minutes.
Thank you, Chairman. And Mr. Rosenstein and Mr. Ray, thank you both for your service, and I hope you pass along my thanks to the men and women who serve the Department of Justice and the Bureau. This morning, Donald Trump, our president, tweeted, "When is Bob Mueller going to list his conflicts of interest?" Mr. Rosenstein, does Bob Mueller have any conflicts of interest?
Chairman, if there were any conflicts of interest that were brought to our attention, I would discuss it with Mr. Mueller, and then there could be review within the department if there were a credible allegation of a conflict of interest. And so I'm not aware of any disqualifying conflict of interest.
In your experience at the department, are you aware ever, in your experience with the department's history, of an unindicted subject of an investigation being given evidence that exists in the case where that person's a subject?
I wouldn't want to comment on what has ever happened, but generally that would not be our practice.
And do you intend to change that with the request that Rudy Giuliani, the president's counsel, has made that unindicted information would be given over to the president as it relates to the Russian investigation?
I'm not aware of any request that Mr. Giuliani has made to me.
Mr. Ray, you agree that the FBI's responsibility is to prevent attacks on America?
That's one of many of our responsibilities, yes.
Would you agree that in 2016, Russia electronically, through weaponizing social media and hacking emails, attacked our democracy?
I think that's a shorthand for what was in the intelligence community assessment, which I have every reason to accept.
This morning, Mr. Wray, the president tweeted, "Russia continues to say they had nothing to do with meddling." Do you believe that Russia had something to do with the meddling that occurred in the last election?
As I think indicated, I think the intelligence community's assessment, which I agree with, is that Russia attempted to sow discord in our country in an effort to influence the last election. As the Deputy Attorney General mentioned, there's also now an indictment through the Special Counsel's Office that speaks to much the same subject.
And Mr. Wray, has President Trump personally told you to use your resources at the FBI to counter future election meddling by the Russians?
We did, as I think the White House has reported and disclosed, we did have a meeting not just with the FBI, but with the Deputy Attorney General, the Homeland Security Secretary. I think Director Coates may have been there, the Attorney General maybe also, where the whole focus was on making sure that we are doing what we should be doing
was the president,
collectively.
Was the president
chaired the meeting, so yes.
Okay. Did he personally, though, express that he wanted the FBI to devote resources to counter Russian meddling?
I don't remember the exact words in the meeting, but the gist of it was to make sure we're doing, all of us, not just the FBI, but all of the parts of the government that have responsibility for protecting our country against foreign influence, that we're all doing what we should be doing. If there's more that we can be doing, that we're doing that.
Mr. Rosenstein, has President Trump contacted you either personally, by phone, or in writing with respect to the Russia investigation?
Sir, in my capacity as Deputy Attorney General, I do have meetings with the President, and I don't discuss my conversations with the President other than to say I have not received any improper order from the President to do something that I believe was wrong.
What would you do if the President did give you an improper order?
Well, I wouldn't follow any improper orders, sir.
I've read the Inspector General report about Mr. Strzok, and I've heard how he's been characterized today, and I, too, share your belief that he acted inappropriately, and we shouldn't allow opinions to get in the way of law enforcement duties. And the Inspector General found that he had opinions that were distasteful, especially toward our president, candidate Trump, but that there was no finding that that influenced the investigation. I just want to ask, are you aware of Mr. Strzok setting up a June 9th meeting at Trump Tower where the president's son-in-law, and campaign chairman met with individuals seeking to offer dirt from the Russians on Hillary Clinton? Did he set that up, or was he involved in that in any way?
I have no personal knowledge about that.
And did Mr. Strzok ask candidate Trump, or write a speech for candidate Trump in the summer of 2016 to invite the Russians to conduct further hacking? Was that a part of any finding that you had?
Not to my knowledge.
Do you find it, Director Wray, unhelpful that the president would tweet in the manner that he did this morning, and the public comments he's made where he doesn't acknowledge that Russia interfered in our election, yet you are tasked with trying to counter Russian interference in our election?
Congressman, there are a lot of opinions out there about a lot of things, including on Twitter. I'm not really a Twitter guy, and our folks aren't really either. We're more focused on just trying to make sure we get our work done.
Thank you, and the country's counting on you as we go into the midterms. I yield back.
The gentleman from Georgia, Mr. Collins, is recognized for 5 minutes.
Thank you, Mr. Chairman. Just a few things. I think one of the interesting things here is, it's amazing how his whole win, especially the last few minutes where we just went to making crap up. But it's an interesting process here. And one of the problems goes back, though, to before you got there. And this is the problem that this committee saw in the previous Attorney General and the previous FBI Director and the previous previous two Attorney Generals, to be honest, in this, in which things were done out of order, out of sequence, meeting with former president on the tarmac, not disclosing it. These are the things that have just led to some distrust as we go forward. I just have a few questions, specific questions, and these can be, without commenting on an ongoing investigation at all of any kind, is there, in your opinion, a constitutional standard that guides your department in investigating any president, a president or any president? Ms. Rosenstein.
Is there a constitutional standard?
Yeah. Do you think there is or is not?
I'm not aware of any provision in the Constitution that addresses that.
Okay. Is there an Office of Legal Counsel opinion that informs the department in this area? And if so, are you directing Special Counsel Mueller to follow it?
You're referring to the issue of whether a president can be indicted?
And well, not just in the sense of how these investigations are to be handled. I think that's been a lot of this conversation that we've had around.
I know that there are two historical opinions, but I have not read them.
Okay.
I mean, I haven't read them recently. I probably have seen them at some point, but I'm not in position to comment on the details of them, and I don't recall whether it's a constitutional issue or not.
Well, I think it does. It just goes to the indictment as well. I mean, it does go to that issue as well. Has there been any discussion about that? Is there a possibility of indictment or non-indictment of that, of the president?
I have not, Congressman, commented on anything about who may or may not be indicted. All that speculation that you read, sir, has nothing to do with me.
And that's fine, and that's why you're on record here and answering the questions, and I appreciate that, and with you both. Let's go back to something, though, that I asked you, that you and I had a conversation about a few months ago, and this was Mr. Strzok's issue. I asked you at the time, did he have his security clearance? You said that you would check. You would assume he did at that point. It now appears that the security clearance has been revoked. The concern I have here is, again, process inside the Department of Justice on what happens when you have someone of his caliber, counterintelligence level. This is not a new recruit. This is somebody who's been around, who's had very sensitive information. And on January 13th, 2016, an individual from the FBI's Washington field office emailed Mr. Strzok and other employees that their polygraphs were out of I think that was out of scope. I asked you about that and asked you if he had been polygraphed. You didn't know at the time. It said the polygraph raised flags. Now, my question about this would be, you didn't know about the polygraph at the time. We'll just assume now that it is out there you do. Would the topic of the extramarital affair have come up in that polygraph, or a possibility come up in that polygraph on Mr. Strzok that could have put it out of scope?
I do not know the answer.
Either way.
I have no idea what would have been raised in any specific person's polygraph at this moment.
Could he have passed a polygraph, given the text, and I'm putting this in context of the text that we see now before continuing in very sensitive areas such as the investigation, the Mueller investigation, again, the Hillary Clinton, but knowing the bias that we have seen, that we've commented on today, if those texts taken into account were on this polygraph, and could he have passed a polygraph if he, on his own ability, denying an affair with Lisa Page?
Well, Congressman, I'm not going to engage in hypotheticals, especially hypotheticals when, as I've said before, we have referred a number of individuals mentioned prominently in the report to our Office of Professional Responsibility for the appropriate disciplinary process, and my commitment to doing things by the book includes not, as FBI Director, commenting on them while they're ongoing.
Okay, let's go back to process and personnel here. If they're out of scope, do you think it's interesting that you would continue to have someone in an investigation of such magnitude and sensitivity who've basically had a failed polygraph or an out-of-scope polygraph test in which they had to then go back and re-answer or complete sensitive compartmentalized information requests on this? Would they stay in that investigation? And if so, were they treated differently because of his position or who he was?
Well, again, I'm not going to engage in hypotheticals about individuals that may have been referred for our disciplinary process.
Does it not strike you as strange, though, Mr. Ray, and I was not going here, but now you've led me here. Is it not strike you strange that someone who has had an issue with a polygraph during the investigation which you have, in which sensitive information were coming about, in which we've now seen the text and other things, what would be that? So could they just flunk a polygraph and you just keep them on? If they could flunk questions, do you keep them on sensitive information simply because that? Not particularly Mr. Strzok here. I'm talking an overall policy. Is your policy just to keep people around that lie?
Of course not.
Okay, then why would we have an issue here in which there is at least an assumption that something is not right? How did this individual continue to stay on investigations when there is polygraph evidence where he had to go back through and say it's out of sorts? And we know that from one of those, the other employees were in a relationship and later got married and disclosed that relationship. So how was this individual kept in an investigative role in this when there was a sensitivity factor here of possibly lying or even now we know bias?
Well, the time the gentleman has expired. The director.
I would like to respond. As I have said repeatedly, we are going to hold people accountable and make sure that we follow our policies strictly. And that does not include me commenting on pending matters involving those people. I want to make sure that people are held accountable, but I want to make sure it's done right and by the book, and I'm not going to do it any other way.
And I understand that, Mr. Director, but also I'll say this, and Mr. Rosen, you made this comment. I appreciate the comment earlier. You said this needs to finish appropriately. And my question is what, and then I'll finish with this and just say, what time is appropriately, and what does it look like?
Time of the gentleman has
Chairman,
expired, but Mr. Rosenstein can answer the question.
I clarify my earlier answer, Mr. Collins. I apologize. I think I misunderstood. You're asking me about department policies. If you're referring to issues of, for example, whether you can issue a subpoena, that may be what you had in mind in terms of process. And so, if those issues arose, we would do an appropriate review as to what the facts and the law are, and we make an appropriate decision. And my answer was simply focused on your original question. I don't think anything in the Constitution directly addresses that, but certainly there could be constitutional issues.
The chair recognizes the gentleman from Illinois, Mr. Snyder, for 5 minutes.
Thank you, Mr. Chairman. I want to thank my colleagues for allowing me to jump ahead and have the opportunity to have the questions. I want to thank Director Wray, Deputy Attorney General Rosenstein, for your patience here, but more importantly for your resilience. And as you said publicly, Deputy Attorney General, refusal to be intimidated. I think it's critical that the investigations be allowed to go to their end, and we and all of our responsibilities follow them to their conclusion and follow our responsibilities to the Constitution. Deputy Attorney General, as my colleague from Florida was speaking to you earlier about the importance of the Mueller investigation, especially in the context of protecting our elections, I'm going to paraphrase what you said, but I think it's important to reiterate. You said the investigation is tremendously important. It's important to understand what's happening now, what happened in the past election, but also what's likely to happen in the future. We have to be certain to do everything we can to protect the American people in our elections. Is that a fair paraphrase of what you said?
Yes, sir.
And I'll add that we have to ensure that every American has the confidence in the integrity of their own vote and the integrity of our overall elections, and it's important to make sure we understand what's happening and we defend against it. Deputy Attorney General, are you confident that we are where we need to be today to prevent interference when Americans go to the polls in 4 months?
Congressman, we only know what we know, and as Director Wray said, he has established a task force. I've met with that task force. And we're continuing to do what we can, along with the Department of Homeland Security, which works with our state election officials. So I can assure you that we're taking a lot of steps to protect against election interference, both with regard to the protection of the ballot itself and with other efforts to interfere.
So last year, each of you came before this committee. I had the opportunity to ask you, I had the opportunity to ask the Attorney General when he was here about what we were doing. This was back in the fall. I was particularly concerned by the Attorney General's answer to my question of are we doing what we need to do. His response essentially was that we're not where we need to be, quoting, I've not followed through to see where we are on that, but he said he would personally take action to do so. And I asked at that time if he would brief this committee. Despite that commitment to brief us and let us know what's being done, we've been unable to schedule a briefing to understand everything that's happening. I believe Congress needs to know what is being done so that we can better understand whether or not we are prepared and what actions we have to take. My question to you, Deputy Attorney General and Director Wray, will you commit to sending the appropriate representatives to brief my colleagues on this committee to understand what's being done on both the Department of Justice and the FBI?
Congressman, a couple things. First, I'm not sure if you were at the, we did a full House of Representatives briefing.
I was there.
And so I'm happy to do additional briefings on top of that, but we are doing a number of things to brief committees and members of Congress on all the things we're doing. I guess the second thing I would say, you referenced the Attorney General's earlier testimony on the subject, and I think it was a question to me when I testified in front of this committee in December.
I did ask you that, right.
And as I said, there are a whole lot of things that we're doing, and that's on me for not having at the time. He now has gotten much more extensively briefed, but that's on me for not having briefed the Attorney General on all the great new things the FBI is doing on that subject.
Okay. I appreciate it, and I've had the chance to meet with the clerks of the 2 counties I represent to understand what they're doing and what their help. There's a report that there was a meeting last month in Silicon Valley between 8 tech companies and representatives of the DOJ and the FBI. Are you aware of that meeting?
There have been a number of meetings with companies in Silicon Valley. We are working closely with them in appropriate ways to try to enlist, in ways that are, again, appropriate, their assistance in trying to better protect the country from improper, malign influence.
And I want to correct the record, it's between DHS and the FBI, but some of the reports that came from that meeting is that there was a sense of an unwillingness to cooperate, collaborate with tech companies to make sure that they are aware of any efforts that might be undertaken by foreign entities or otherwise to interfere in elections. Has your agency provided to these companies what they need to make sure they are able to put up the defenses and respond to any threats?
I will say, Congressman, this is the first time I've heard any complaints about what information we're providing, again, under the new efforts that we're making. We've actually provided all sorts of information to those companies in an effort to make them more effective. And I think from our perspective, we're now looking to see what they come back to us with in order, as again, in a joint coordinated effort to protect, they have to protect their own platforms. We're providing them information to help them do that. So my own experience, including having gone out to Silicon Valley and met with some of these companies myself, is that we're doing a whole lot of things that weren't being done before the 2016 election. And
I appreciate it. And like I said, these were reports, so I don't want to make any claims, but I do want to make the request that we work in partnership with the tech companies to do everything we can to ensure that every American's vote is counted fairly and every American has confidence in their vote and the ultimate election. The American people are counting on you both. And with that, I yield back.
Thank you.
The chair recognizes the gentleman from Arizona, Mr. Biggs, for 5 minutes.
Thank you, Mr. Chairman, and thank you, gentlemen, for being here today. The Inspector General testified that Peter Strzok led the investigation, both for the email investigation and the initial Russian investigation. Would you agree with his characterization of that?
Well, I wasn't there. I do think it's fair to say that Mr. Strzok played a lead role in both investigations. Exactly how it was structured and who supervised whom, that's probably subject to a little more context and explanation by others, but I don't think that's far off.
Fair enough. And then, so what's been characterized today is that the finding of the Inspector General is that there was none of the bias that has brought Mr. Strzok into such, under a microscope so closely, affected the decisions made in the Hillary Rodham Clinton investigation. But that's a bit of a mischaracterization because under questioning, and let's just go there. You probably have the book right there. If you go to page 211, I think it is. Let's see here. Nope. Page 149. What you'll find, and this is one thing the Inspector General testified as well, is that he did not find documentary testimony evidence that improper considerations, including political bias, directly affected the specific investigative decisions. But when we explored it, he admitted that those biases that Mr. Strzok had, and not just Mr. Strzok, but the others listed that I think have been referred for discipline, probably indirectly affected not only the information the decision makers had, but the decisions that were made. Would that be accurate? I know neither one of you were there, but do you think that might be accurate?
Well, Congressman, I think I'm going to let the Inspector General's report speak for itself. I don't
I'm talking about his testimony, not his.
Yeah, no, I wasn't here when he testified.
Yeah, it was. I didn't expect you to be watching, as riveting as it was. So, so that leads me to a series of questions related to what's going on here, and we move into the last investigation, the ongoing investigation. So I'll go to you, Mr. Rosenstein. The scope letter. Who wrote the scope letter for Mr. Mueller's, what the scope of his duties would be?
I don't know exactly who wrote it, but I'm responsible for it.
You signed off on it, probably.
Correct. And
have you turned an unredacted copy of that over to any congressional committee?
Not as far as I know.
Okay. And why is that?
Congressman, I really appreciate that question because I understand why there's some confusion about this. And we only have 2 minutes and 7 seconds, but I wrote in my letter dated yesterday the history and the explanation of why it is wrong for the Department of Justice to publicly identify people who are subjects of investigation. So I certainly completely understand why you asked the question, but I hope that the letter will speak for itself in explaining why it is our policy not to do that. Now, people have deviated from that in the past, and my commitment is to follow the rules. That's a commitment I made to the Attorney General, Jeff Sessions, when I took this job. And I recognize it's confusing because people have departed from the rules in the past. We're following.
But we're talking specifically the scope letter. So,
yes, sir.
So, okay, that's.
We do not identify persons, as is disclosed in the portion that's made public. We don't identify persons publicly unless they're charged, and we explain that in the letter.
Okay. So let's go into, I sent you a letter, and I don't know if you got it because it's just a couple days old, June 25th, asking if you were going to provide us with the names of everyone who has served past and present on Mr. Mueller's special counsel investigation, because as you might guess, we're kind of curious what vetting has gone in. The Inspector General found, at least in his testimony, that there was still probably one person still on that investigative team that he found to have untoward bias. And so are you inclined to release that, or is this something you and I need to talk about offline?
Sir, when I took this job, I committed that I was going to read every letter personally.
Good luck.
Mr. Boyd pointed out that's not practical, so I haven't been able to do that. I completely understand that question. We'll review it. Obviously, our administration is very committed to backing the blue and protecting law enforcement officers from any kind of abuse or retaliation. I'd be reluctant to publicly name people who aren't on the front lines just because of what that might invite, not by you, obviously, but by people who are ill-motivated. But I think you raised an important question. I have talked with Mr. Mueller on several occasions about the importance of making sure the people on his team.
Okay, I don't want to cut you off, but we'll get back to that maybe offline or something like that. But so I've got 10 seconds left. This is important. September 2nd, 2016, Lisa Page wrote a letter to Mr. Strzok saying that she had talking points for Director Comey because POTUS wants to know everything we're doing. Please identify POTUS and what do you think she meant when she said once.
I don't want to speculate on what Ms. Page meant. I do want to say, if I may, Congressman, I think it's important for you to understand that I completely understand the President's frustration with what's reflected in this report. I mean, nobody would be happy to know that people were sending those sort of text messages and they have those kind of views. And so I completely understand his frustration. My commitment is to make sure that everything that we do accords with the facts and the law, and we do not allow any bias to influence what happens on our watch.
Gentleman's time has expired. The chair recognizes the gentleman from California, Mr. Liu, for 5 minutes.
Thank you, Mr. Chair. Let me start by saying it is ridiculous and stupid we're having an emergency hearing into an investigation of Hillary Clinton's emails in 2016. It is now June 2018, and thousands of kids have been ripped away from their parents by the Trump administration's child separation policy. They have not yet been reunited, and the kids not knowing if they're ever going to see their parents again or where they are is a trauma and horror we can only imagine. But since Republicans control the agenda, let's at least try to have this stupid hearing be based on the facts. And the central fact from this IG investigation is that no personal views of any FBI or DOJ employee affected their integrity of the investigation. So, Director Wray, I'm going to read to you some of the findings from this IG investigation, as if you agree with it. The IG found our review did not find evidence to connect the political views expressed in the text messages to the specific investigative decisions. Do you agree with that?
We accept the finding, yes.
All right. It further found that the investigative decisions were the result of discretionary judgments made during the course of an investigation by agents and prosecutors, and that these judgment calls were not unreasonable. Do you accept that finding?
We accept that finding.
The IG report further found, in fact, that Agent Strzok advocated for more aggressive investigative measures against Hillary Clinton, including the use of grand jury subpoenas and search warrants to obtain evidence. Do you accept that finding?
We accept that finding.
And the reason Agent Strzok did that is because in America, we let people have personal views. But we expect that when they go do their job, when they enter the FBI building, they check their views at the door. That's what we expect of our agents. And in your case, Director Wray, you're a Republican, nominated by a Republican president, confirmed by a Republican-controlled Senate. You have made over $39,000 exclusively in donations to Republican candidates. I still trust you because you check your beliefs at the door and you're doing your job. And in fact, when you interview agents to hire, you can't ask them if they are a Democrat or Republican and whether you should hire them. Isn't that right?
That is correct. I will say, Congressman, that I take very seriously our obligation to do our jobs apolitically, independently, and objectively, no matter who likes it, either side. I will also say that we don't subject our agents to political litmus tests. I will also say that we expect our agents to check their opinions, as you said, at the door, not unlike in this system, judges all around the country who have their own political views that range across the spectrum and sometimes hold them very deeply, or juries that have all kinds of views, or doctors that hold all kinds of views. All of them are entitled to have those views, but we need them to check those views at the door and honor their oaths, and that's what I expect of every agent, analyst, and professional staff person in the FBI.
Thank you. I deeply appreciate that. I was at the closed hearing of Peter Strzok yesterday, and I just have to say my Republican colleagues have mischaracterized his testimony. A number of his text messages have been misconstrued and mischaracterized. It is deeply ironic that my Republican colleagues are yelling and screaming about document production when they refuse to release his unredacted transcript from yesterday's closed hearing. They need to release it to American people. We need to see Peter Strzok's testimony, and he needs to be at an open hearing. I hope my Republican colleagues will do that. Now, let me move to something that the President said in an official statement on Twitter. He said a number of times that we've got a deep state. So I asked in another hearing, Secretary of State Mike Pompeo, was there a deep state at the State Department? He laughed, and he basically said, no, there was not. So, Director Wray, I'm going to ask you, is there a deep state at the FBI?
Congressman, I've never completely understood the term deep state. What I can tell you is that we have 37,000 men and women working in field offices all over the country and in legat offices all over the world, and they are people of character, of courage, of principle, of selflessness, and of patriotism, and that's the FBI that I see.
Thank you. I appreciate that, and I hope the President stops attacking the FBI. And then let me conclude my comments to you, Deputy Attorney General Rosenstein. You have shown immense courage in the face of unfair criticism and overreaching requests. Stand your ground. You took an oath to the Constitution, not to any particular administration or political party or even this Judiciary Committee. Do not produce documents that would jeopardize people's lives. Do not produce documents that can threaten sources and methods. Do not produce documents that will affect an ongoing investigation. Stand your ground. Play it straight. Do it by the book as you have been doing. And history will judge you kindly for that. I yield back.
The chair recognizes the gentleman from Pennsylvania, Mr. Rothfuss, for 5 minutes.
Thank you, Mr. Chairman, and thank you, gentlemen, for being here today. Again, let me also echo my thanks to the Department and the FBI for the tremendous work that's being done in Western Pennsylvania as we grapple with any number of issues, from the heroin epidemic to cyber issues, et cetera. I want to go to Mr. Rosenstein. The IG report noted that there were discussions about whether to employ a special counsel, but Mr. Horwitz's recent testimony was that Attorney General Lynch made the decision that she did not need to recuse. Furthermore, on page 5 of the report summary, the IG's team said, quote, we did find evidence that Comey never seriously considered requesting a special counsel. Do you think that Attorney General Lynch should have recused herself, especially after meeting with former President Clinton on the tarmac in Arizona?
Congressman, I don't have any opinion about that. I would recommend you ask Attorney General Lynch. I don't know what her state of mind
was. What level of interaction can an Attorney General have with a potential witness of a criminal investigation before they should recuse themselves?
Every case, Congressman, is evaluated based on the facts and circumstances. I believe she said that she consulted with ethics experts, and that's what I would do as well. So I don't know what the nature of that conversation was.
I would hope that if a situation similar to what she encounters you, there would be a recusal. Throughout this report, decisions related to the investigation were politically driven, whether or not they were partisan. I see evidence of them wanting to wrap things up because of an impending election. On page 4 of the summary, Director Comey also had conversations with Deputy Attorney General Yates about insisting that a special counsel be appointed the closer they got to the election. But his statement to Yates was really to pressure the DOJ to induce the department to move more quickly to obtain the Mills and Samuelson Culling laptops and to complete the investigation. I see decisions with respect to Director Comey's statements on July 2nd, October 28th, all driven by politics. And so we just had a conversation about whether what's going to control the timelines of investigations. Again, I see politics driven throughout this. Do you not?
Congressman, I do. If I could address the preface to your question, Attorney General Sessions and Director Wray and I have an understanding that we're going to have a candid relationship. We recognize some of the things that went wrong may have involved personal interactions between leaders of the department. That's not going to happen on our watch. With regard to the Inspector General's report, I wasn't there. The Inspector General did a very thorough investigation. I would have to respect his conclusions.
A little bit about the special counsel. How is the power of the special counsel limited? The special counsel has the same powers as a U.S. attorney, correct?
Within the scope of his responsibility, yes.
A U.S. attorney can be discharged at will by the president?
A Senate-confirmed U.S. attorney can. We also have
Correct.
some non-Senate confirmed U.S. attorneys.
But the regulation that appoints the special counsel does not provide for such, correct?
Correct.
There has to be for
Makes him a
cause.
subordinate official. So unlike a U.S. attorney, he can be fired by the Attorney General, which a U.S. attorney would technically require the President's.
Well, there's a question about subordinate, and I just want to ask you that. There's some in the legal community have made an argument that Mr. Mueller's appointment violates the Appointments Clause of the Constitution, essentially pointing out that he is operating as a principal officer instead of an inferior officer, which does require presidential nomination and Senate confirmation. Are you aware of these arguments, and do you have an opinion on them?
Yes, I'm aware of the arguments. I believe they're wrong, but law professors are free to make whatever arguments they like. Defendants can make whatever arguments they like and have them adjudicated. I'm fairly confident that the argument is wrong.
Question about the frustration that we've had with respect to documents and redactions. I think I've heard you say today that you want to help us with what you call legitimate congressional oversight, and that you would provide information that we need to fulfill our duties. Who is the arbiter of what is legitimate and what you think we need, as opposed to us making that decision?
I don't know that I used or didn't intend to use legitimate in that context. All what you're doing is legitimate. The question would be whether or not a particular document was withheld for a proper reason. And my understanding, Congressman, I know you aren't personally involved in these discussions, Mr. Lausch is. My understanding is that we actually have a fair amount of agreement with regard to...
Understand where this is all coming from, because we see things that are redacted that should have been redacted, things that are redacted to protect somebody at the FBI, whether it has to do relationship with Strzok and the judge, or with respect to the credibility of a witness in the Flynn investigation. They're redacted, they shouldn't have been, and that it just adds to our skepticism. And documents are withheld, and then you go out and say something about extortion. And extortion,
Well,
I'm looking
I wasn't
at the
referring
elements.
just to the documents, sir.
Well, I
was referring to other threats that have been made.
A crime, I think the word was extortion, and I mean, isn't there an element of money or property of value in that? And again, it adds to the environment that has not been helpful as we look for the information, as we conduct our legitimate oversight.
No, I appreciate that. I think what I said was something to the effect that the department will not be extorted. It wasn't an allegation of crime.
Well, again, you have to use your language. Come on, you're a prosecutor. You know that term is loaded.
No, I understand, Congressman, but I don't think anybody thought I was accusing anybody of a crime. My point is that we have to do the right thing. People are going to make criticisms. People are going to make threats. We need to do the right thing. And I think the American people need to be reassured, Congressman, that we're not going to respond to any improper demands, no matter who makes them. That was simply my point. But I do think what I would appreciate if some of you would keep in mind is the reason you know that those redactions were inappropriate is because when we were asked about it, we turned over the unredacted documents. We weren't trying to hide anything. Now, somebody may have made a mistake in the redaction process, and as I said, I acknowledge
that, but I see my time has expired.
The FBI was following protocols for these redactions that we determined were wrong, and we changed them. So I think we've resolved that, and so I believe that we're acting in good faith. I think the folks we're dealing with understand we're acting in good faith. I met personally, along with Director Wray, with Chairman Goodlatte and Chairman Nunes and Speaker Ryan, and they brought to my attention some specific items which we're addressing. So I believe, Congressman, that we are complying with valid oversight requests, and we're going to provide you everything that's relevant and appropriate for us to provide.
You recognize the gentleman from Maryland.
Mr. Chairman, thank you. The chairman said earlier this morning that this was like a novel, but he didn't say which one it was. I've been experiencing something like Alice in Wonderland, although the early questioners reminded me a little bit more of the 2-minute hate sessions in George Orwell's 1984. I don't know whether either of you wanted to volunteer a literary analogy for us to understand what's taking place today. Okay, no? All right, well, if it occurs to you,
We'll
let
have to
me
think
know.
about that, Congressman.
Our Republican colleagues seem really upset with the Department of Justice and the FBI to the point of rudeness and incivility, but I can't quite figure out why. Starting with personnel, Mr. Rosenstein, you are a distinguished law enforcement officer of 21 years' experience in law enforcement. I know that you were a Republican appointed by a Republican president to be U.S. attorney, and as far as I know, you're still a Republican appointed by a Republican president, President Trump, to be the deputy attorney general. Robert Mueller spent 28 years in law enforcement. He was a U.S. attorney in 2 different states, a decorated war hero, again, a lifelong Republican. And Mr. Wray, I understand you've spent at least 8 or 9 years in law enforcement. You have been also a Republican, a lifelong Republican. You've given tens of thousands of dollars to Republicans and to your law firm's political action committee, including to candidates like John McCain and Mitt Romney, and so on. Is there a Republican partisan conspiracy and witch hunt against a Republican president taking place, Mr. Wray?
Congressman, as I've said repeatedly, I do not believe Special Counsel Mueller is on any kind of witch hunt.
Okay. The special counsel has actually been remarkably productive in its work. 22 people and businesses have been charged with 75 criminal charges. There have already been 5 guilty pleas from Michael Flynn, Rick Gates, George Papadopoulos, Alex von der Zwaan, and Richard Pineda. One person's already been sentenced. You could compare that to the Ken Starr Whitewater investigation, which lasted 4 years and produced nothing, or the 7 congressional committees that went after the Benghazi Holy Grail and came back with nothing, including our beloved Mr. Gowdy. That took more than 3 years, and yet in less than 2 years, we've got 22 people and companies charged. Have there been any complaints about the guilty pleas or those criminal indictments from any members of Congress that you're aware of, Mr. Rosenstein?
Sir, if I could just make 2 corrections. I've spent 28 years in federal law enforcement, 29 years in the service of the government. I sometimes round up to 30. With regard to the Starr investigation, I would take issue with your suggestion that it produced nothing because, as you may be aware, I worked in that investigation. I was involved in a trial that resulted in the conviction of 3 defendants for fraud. But the Starr investigation, as I discuss in my letter of yesterday, is somewhat different. Director Mueller understands that the goal here is to keep the investigation focused and to conclude it as expeditiously as possible.
Well, and I appreciate that. And of course, the purpose of any criminal investigation is justice, ultimately. And we need to allow law enforcement to proceed on its own terms, following the rules and the procedures of law enforcement in order to arrive at a just result. But the whole suggestion here today is that there's some kind of partisan conspiracy afoot. And let me just ask you, just to be clear about it, Ms. Rosenstein, is there a Republican partisan conspiracy within the highest ranks of law enforcement at the Department of Justice against a Republican president?
No.
Okay. Do you believe that the complaints that are being directed at you today are because you're not doing your jobs or because you are doing your jobs? Starting with you, Mr. Rosenstein.
Well, Congressman, I'm reluctant to characterize what people's motivations are, but I can assure you that we are doing our jobs and we're doing them properly.
Okay. Mr. Gowdy said before that America is being torn apart. And of course, we've seen in the last several weeks thousands of families actually being torn apart in America. But I agree with Mr. Gowdy that America is being torn apart by these outrageous and incessant attacks on distinguished law enforcement personnel at the Department of Justice and law enforcement officers at the FBI for partisan purposes. All of this presents a huge threat to the rule of law in America. One party controls the House of Representatives, as you've seen today, the United States Senate, the White House, and the Supreme Court, obviously, after the sandbagging of President Obama's nomination of Merrick Garland to the Supreme Court. So they control the House, the Senate, the White House, and the Supreme Court, and they seem to want to control the Department of Justice and the FBI. So I just want to ask you, can you restate what you think the role of law enforcement is in terms of upholding the rule of law against attempts at partisan interference and manipulation? Mr. Wray, could I begin with you?
Congressman, our mission is to protect the American people and uphold the Constitution, and that is our only loyalty.
Okay, and Mr. Rosenstein?
Congressman, I understand the concerns about the controversial nature of this investigation and of the things that are happening. It would have been better if Russian agents had not interfered with the election. It would have been better if folks who have acknowledged that they lied to the FBI had not lied to the FBI. It would have been better if people had not made these mistakes and demonstrated this bias, but we're in a position where those things have happened. The best that we can do is to try to do our jobs faithfully, to obey our oath, and I believe, Congressman, that ultimately the American people will regain, those who have lost, will regain confidence because they know they have Chris Wray running the FBI properly. They know the folks running the department are making decisions properly. And my hope is that that will be the end result. But I recognize people have legitimate reasons to be concerned.
Thank you for your service. I yield back, Mr. Chairman.
Chair recognizes the gentlewoman from Washington, Ms. Jayapal, for 5 minutes.
Thank you, Mr. Chairman, and thank you both for your service. Thank you to the men and women at the FBI and the department. We deeply appreciate it. And I want to just start by registering my I was trying to find the right word. I had confusion here. That wasn't quite right. Then I had disgust. Then I put outrage. Now I'm just going to say dissent and displeasure that we are having a sham emergency hearing on this topic when we already held an all-day hearing with the Oversight Committee just last week when Peter Strzok was deposed for 11 hours in a closed session where we discussed this in the context of the Meadows resolution of inquiry on Tuesday at markup and then again on the floor. And I can only conclude that the only emergency really that requires the chairman to break committee rules and schedule a hearing at the last minute appears to be the majority's deep fear of the truth of what the special counsel Mueller's investigation is yielding and will yield around the Trump campaign's collusion with a foreign government and other related matters. That has been the emergency that frankly has transformed a committee that I was so excited to be on because it is a powerful committee. The Judiciary Committee is a powerful committee with independent jurisdiction and the profound responsibility to hold our democracy to its highest ideals, and that has been transformed into a committee, in my opinion, with a singular political partisan focus and what I can only describe as a naked fervor to spend all its time in service to individuals, including a president, who continues to show extreme disregard for the very institutions that Republicans used to defend all the time and Democrats actually used to criticize, the institutions of democracy, the FBI, the Department of Justice, the media, the courts. The chairman mentioned this story is like a novel. What came to my mind is The Handmaid's Tale, perhaps. A tale that leads up to the rights of citizens, the status of women, the pillars of justice and democracy being destroyed in service to authoritarian power. The real emergency in my mind that we have not had a hearing on is the urgent humanitarian crisis occurring in our country, at our border, and in cities across the country that really does demand our immediate attention as our government risks the long-term health well-being of thousands of young children who have been cruelly separated from their parents, who have been put into cages on United States soil, while their parents, who are, by the way, guaranteed the right to seek asylum in this country, guaranteed that right by our signatory to the International Convention of Refugees and by our own due process laws, that they have been imprisoned. That's the emergency that we have. And so I would like to start my questioning by asking Deputy Attorney General Rosenstein, are you aware of the letter written by 72 bipartisan former U.S. attorneys who wrote to Attorney General Sessions to end the, and this is their quote, tragic and unsustainable, end of quote, family separations, saying that they were, again, their word in quotes, horrified by the policy. Are you aware of that letter?
I believe I read about the letter. I don't think I actually read the letter itself.
Mr. Chairman, I ask unanimous consent to enter that letter into the record.
That objection be made a part of the record.
Thank you. Attorney General Rosenstein, are you aware that the spike in the number of migrant children in U.S. custody today has gone to over 10,000 children in detention centers?
No, I'm not aware of the number in detention centers. I don't think that may include children who've come across on their own without
It
parents.
does?
But I'm not aware of the number in detention centers.
And are you aware that overall over 2,700 children have been separated from their parents, including children as young as 6 months old?
I do not know that for a fact, Congresswoman. I'll accept your representation.
Thank you, Attorney General. I actually went to visit women in a prison. They're being held in a federal prison. I'm not exaggerating when I say they're being imprisoned. Asylum seekers who are being imprisoned, mothers who told me their children have been stripped from them, one as young as 1 year old. And Attorney General, I don't believe that the administration knows even where these children are, who they belong to.
Congressman, I appreciate you raising that. I met just the other day with Secretary Azar, and he was quite emphatic that is a false story. That HHS does know exactly where every one of those children
Attorney
is.
General, let me just stop you for 1 second to tell you of my personal experience, and I was surrounded by the warden of the prison, as well as a number of employees who can clarify, who can corroborate exactly what I'm saying to you. A woman gave me a slip of paper that was given to her either by ICE or HHS. I'm not sure who gave it to her. It had her name, her A number, her supposed children, except they weren't her children. They were not her children. Please do not believe when somebody tells you that they know where these children are, unless you can tell me in 10 days that they are actually going to be reunited with their parents. This is happening on U.S. soil. And I have been very disturbed to hear of some of the other consequences on the Justice Department's ability to prosecute serious crimes due to this zero tolerance, zero humanity prosecution policy. A USA Today article said that an email...
The gentlewoman has expired.
An email was obtained from a Justice Department supervisor. I will turn it over to you, and I would love to hear what is happening to prosecution of drug smuggling cases, because prosecutors are being taken away to prosecute these individuals who are coming across seeking asylum.
Congressman, I'd be very interested in that, and I would be shocked if it were true that a drug smuggling case was dropped because of an immigration case, but I'll be happy to look into it.
Thank you. I appreciate that.
Gentlemen, you have given us 5.5 hours of your time, and that's short by our standards here lately, actually. The Inspector General was here for 7 hours, and Mr. Strzok was here for 11 hours yesterday. But I want to just repeat the concern expressed by some of our members and myself about the interview with Mr. Strzok. We reached an agreement with him after we had issued a subpoena because his earlier promise to voluntarily appear was not materializing, so we issued a subpoena, and then we later agreed to turn it back into a voluntary interview. And he came, and as is the prerogative with a voluntary interview, the FBI was allowed to have counsel present as well. We went through a lot of questions about a lot of things for which we got answers, but we also were stymied time and time and time again because the FBI counsel instructed him not to answer because it was, as she called it, an ongoing investigation. Now, we have an ongoing investigation here as well, and that investigation is based upon that book sitting between the two of you. It took a long time to get that done. And we have worked very hard for a long time before that, and we continue to work on that. And Mr. Strzok was expected to answer questions regarding his involvement in both of these investigations, not from the standpoint of the substance of the investigation, but from the standpoint of what his role was in a contemporaneous time with some of the most unbelievably, outrageously biased, vulgar texts that he was exchanging at the same time that he was being introduced into this investigation. So questions regarding his, has he ever communicated with Mr. Steele or with Glenn Simpson, who's a journalist, or other matters like this, to find out what his role was in the start of that investigation is critical to our investigation. And we need the answers to those questions, and we are now being blocked again by the FBI. So I will say I completely agree with both of you, and actually I commend both of you for the efforts that you have made with regard to the document production. I was dismayed to find out that someone in the department had made the determination that even though our correspondents had always said that we wanted all communications, that somehow that would exclude the communications within the Department of Justice related to these very same matters. And I'm understanding that Mr. Losh is working on that and will help us resolve that. We also have the issue with regard to, this is more the Intelligence Committee, but this a matter of the FISA investigation which the Inspector General has now undertaken is very much of interest to the Judiciary Committee because both the FISA court and the FBI are under the oversight of the Judiciary Committee. But so we're as interested as others are in the information regarding how that took place. And I don't think the Congress should be expected to wait another 6 months or a year. That report was in the works for, what, a year and a half maybe. It was many months overdue from when we were originally advised they expected to have it done. We understand that. It takes a long time to do some of these things. But our investigation needs to proceed simultaneously. And I have, and other members of this committee have, and Mr. Gowdy has on behalf of the Oversight Committee, said we have no intention of interfering with the substantive investigation of Mr. Mueller. We've been criticized, in fact, from people both sides of the aisle who want to dig into that whole matter, and we've stayed clear of that. But looking at the problems cited in that report, which involve questions of improper procedures followed by the FBI and extreme bias demonstrated, and we can all draw our conclusions about how the bias affected the actions, but not if we can't ask one of the central witnesses about that bias based upon his involvement in the outset of that case. So we need to have that resolved, and we will communicate with you further beyond right here to work on that. Finally, let me say,
Mr. Chairman, can I just ask, have we opened a second round of questions?
No, I'm not asking any questions. And we thank both of you. Mr. Ray, I think that you have done what a lot of people said needed to be done in terms of making the necessary personnel changes. I believe there are probably some more that need to happen. I think I liked what you had to say following the Inspector General's report about the recommendations in the report. And Mr. Rosenstein, I absolutely agree with you that you are making an effort, a very serious effort, to change what was earlier on a very slow process in terms of the production of documents. It's been much, 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 much better. I completely agree with that. But this is an ongoing investigation. We're going to have ongoing problems, and we need to keep working on that because of these two new problems that have just come up in the last day. So,
Mr. Chairman, just point of order. As the vice-ranking member, in the absence of the ranking member, I would just hope that our side would be included in any follow-up discussions that you have on the Russia investigation.
We will involve the appropriate parties at the appropriate time with regard to how we're going to get the cooperation to make sure that the witnesses are not instructed not to answer questions that are relevant to this investigation. I thank both gentlemen for appearing here today, and this hearing is adjourned.
Thank you very much. Good, I appreciate it. I'll get right on. Thank you.
It's a pleasure to meet your daughter. I hope she loves Lexington.
Yes, she's looking forward to it. Thank you for talking. It makes a great impression on us.
I wish a lot of things were under different circumstances, but I'm glad I got this.
Thank you very much.
Chairman, you think necessary?